Okay. Once again, hello, Lyric Armstrong, your real estate agent advocate. Here going crazy, 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 crazy. I think I'm using two different um, platforms. That's what I think I'm doing. But I know I'm going crazy, and maybe you two are going crazy. Hopefully, we'll be able to meet each other on the live. Hello, I'm in the kitchen going bananas. And for those who didn't hear earlier, I am happy that there is a part of this judicial system that is taking the Karen Reed trial seriously, that's taking the death of John O'Keefe seriously. I am surprised. There were on day 4 of Jury Watch, but I am very happy that at least someone is paying attention to the evidence, right? So as I'm sitting here kind of concerned, and I don't want injustice to transpire, I'm happy to see that in fact, as we are looking at the OnlyFans, I guess is what we're calling it these days, that in fact someone is taking this trial seriously. So I want to commend the jurors for being committed and for looking at all of the evidence and looking at what does the evidence say versus being like Trooper Proctor and being like, okay, so the conclusion is she did it, so let's just make all the evidence look like she did. Okay, my pool man was here making a whole lot of noise with the water. So I probably was yelling. I apologize. But anyway, so unlike Trooper Proctor, who was just like, this is the conclusion. So whatever evidence we get, that goes to that conclusion. Versus what does the evidence tell us? Where does that lead us? And that's a typical investigation. We would expect that the evidence is collected, and based upon the evidence, you know, you go down the rabbit hole in some regard, or you go down the direction of where the evidence leads you. So hopefully that's what the jury is doing. That's what I'm looking at. So while we brace ourselves and we are on verdict watch, and the fan is a rolling and a rolling and a rolling, let's see what we can do to entertain ourselves, huh? Let's try that. First, put it in the chat where you're coming in from. It's an ominous sound in the in the house. I don't know what that sound is. It reminds me of the windshield wipers. I think. Okay. So I think we'll just go from here. Okay, let's look at the recaps. We're gonna look at defense's closing argument first. Well, okay, let's go to verdict watch and see. Yeah, we're still on the fan. Okay, we'll ignore that for now. And let's go in what Jackson does with the verdict watch. Okay. Okay. Play. Is it playing? It's not playing. Okay. What about
Massachusetts, because the
There we go.
Commonwealth has the burden of proof, the
You hear it?
Commonwealth goes last. So we will hear now.
Knowing that when you're away from the microphone, it's very hard to be heard in the first place.
Thank you, Your Honor. Look the other way.
Okay, so before we look the other way with Alan Jackson, just real quick, understanding that the jurors, this is not evidence to them. Opening and closing statements are not evidence. So the opening statement helps you to kind of take a look at all of the evidence to see where it fits in the theories that are presented. And atypically, it is the Commonwealth that presents the theory, and then the defense rebuts it in some fashion. They'll say Commonwealth is not going to be able to prove that. The evidence doesn't show that. Or the witnesses, you'll hear that the witnesses have, conflicting accounts and are not, hold on one second. And you'll hear different evidence from witnesses that don't necessarily align, so they're competing in theory. And consequently, that's the opening statement. The closing is, remember all of this evidence we supposedly got from the Commonwealth, and the Commonwealth is saying, listen, this is all the evidence we showed you. We showed you exactly what happened. So that's what the closing is. It's not it's not evidence in and of itself. These are summations and conversations relative to theory. Now, Alan Jackson, in my opinion, he does a different type of presentation relative to defense closing argument. He kind of incorporates elements that the prosecution would normally do, which is the evidence shows this, this is what happened. He puts a theory on the table. Defense don't have to put a theory on the table. They don't have to account for what happened. What they put usually is doubt. Oh wait, what's going on here? They say there's doubt. There's no. Oh, I thought we had. Okay. There's no way that this could have happened because there's so many ways it could have happened, right? It's no way for the Commonwealth to say without any doubt, this is the way it happened, because there's so many different ways it could have happened. So consequently, there's doubt. And that's what is typical. All right, let's go ahead.
Look the other way.
The other way.
4 words
Just out.
that sum up the Commonwealth's entire case. 4 words that sum up the hopes of those who have tried to deceive you. Conflict of interest? Doesn't matter. Just look the other way. Magic hairs, magic glass. Look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, butt dials galore. Just look the other way. That's what they want. That's what they're counting on. But the uncontrovertible fact is you have been lied to in this courtroom. And your job is to make sure you don't ever, ever look the other way. Mm-hmm. Your singular duty is to stare down the evidence and do it unflinchingly and do it unwaveringly. You see, you're the only thing.
That is a good point, because the jurors are the fact finders, so they have the highest responsibility. Everyone else in the courtroom might have more experience with trials, depending on how often the jurors are, feel comfortable or they serve on juries, and if they're comfortable in the courthouse. I don't know. So I don't know the jury's background relative to if they happen to be astute to legal matters or not. However, under normal circumstances, you typically have the desire to have jurors that are your peers. That's the goal. And so when you're going through your challenges to determine who's going to be on the jury panel, back and forth between defense and Commonwealth, you're looking for a good representation of the community. The community is more complex and more diverse than those who are necessarily astute or truly, part of the legal process. So I know we had an attorney on. Was that the Trump case? I think the Trump case had an attorney on it, and that was kind of like, wow, they're gonna keep an attorney on there. That's kind of, yeah, yep. That's a little ballsy because attorneys are very critical of other attorneys. We're looking at Alan Jackson here, who was doing the very best, and we're getting ready to be critical relative to his testimony. There are always ways to see something differently. So consequently, reminding the jurors that they are the fact finders and that they have the highest responsibility is extremely important, um, because they're the ones that's going to figure this out. So, as much as I loved the what do you guys call them? Crash Daddy. I guess all kind of names for the experts. The experts are great, who were actual experts anyway. But it's up to the attorney to make it simplified, to bring it into digestible pieces, because anything that is lolly boring, and I don't mean to disparage the gentleman, the attorney himself. I'm just saying his presentation is so overly soothing and monotone to where a lot of times I'm like going to sleep like, wait, I need more coffee. What did he say? Let me rewind. Let me go back. It's hard to follow presentations in that setting that don't have the inflection and don't present and don't give you the drama and help you to focus. And so um, Alan does a great job. He's like, focus in this area, understand that this is the theme, look the other way. He announces it, he re-announces it, he continues to show you what he means by it. And he uses his tonation, his fluctuation of volume, and his presentation of theatrics to keep you engaged and pulled in. And that's good for him, but obviously it didn't take the jury's breath away, right? Because they're still here. I think we're 18 hours in, day 4 of jury deliberation. But as I said, I do not chastise the jury relative to them being intentful. I am glad that they're being intentful, and I'm hoping that their intent is to look through the actual evidence, not to battle the jury instructions, because those were confusing to me. I'm like, come, huh? Like, can we get more definition? You know, and if they're not laborious, then the jury, like the forms, is like, not guilty. My head hurts. But
And
anyway,
stand between Karen Reed and the tyranny of injustice. It's your job you didn't ask for, probably a job you didn't want, but it's the greatest responsibility we have as citizens here in America.
Yeah.
Lest the government stop answering to us.
How many
We
of
start
you
answering to the government.
put it in the chat?
Rooms loads a
Oh gosh, who is this? No, we don't want anything to do with that. Put it in the chat. How many of you will say, I don't want to go to jury duty. I don't want to go to jury duty. Who says that? Right? Oh my gosh, what's going on here? Sorry, hold on. My computer is stuck on my end. It won't let me Okay, cancel that. And then I want to leave the gummy berries alone, whatever those gummies are. I don't have anything to do with the gummies, okay? We're gonna stop sharing gummies. I don't want you to be like, oh, that's mm-mm. Hopefully they're vitamins, but I don't know what it is, and I'm not trying to find out either. Anyway, how many of you put it in the chat? How many individuals will be willing to be the brave soul and admit to that fact that they have on more than one occasion been like, I don't want jury duty. And you call in, you're like, please don't call my name, please don't call my number, please don't call. Oh, and you're happy. And you're happy not to have jury duty, right? That's what Alan is talking about. He's like, look, you have been brave enough to get here. You've been brave enough to to go through this trial. Fortunately, the Commonwealth wants you to look the other way, but please don't look at the evidence. And so, hello, once again, put in the chat where you're reaching us from. Glad to have you. We're sitting here watching the Only Fan, waiting for the jury. We're holding out for a jury verdict. And I'm not trying to lose my mind because I'm hopeful and grateful that the jury is, in fact, taking it seriously and looking at the evidence and not just coming to a rush decision. Though I saw the evidence and I felt like there was a great chance that by next day we'd have a response from the jurors. They wanted to see the evidence a little clearer for themselves, a little more intently, had some questions, and now we're just reflecting on Alan's great job at closing.
And woe betide anyone,
While we wait.
any one of us,
Well, why would we
who
wait?
might find ourselves in the crosshairs of a Michael Proctor. Preparing for today, I was reminded of a quote. It's a quote about the truth, and I want to share it with you. It is of great importance to set a resolution never to tell an untruth. There is no vice so mean, so pitiful, so contemptible, and those who permit themselves to tell a lie once find it much easier to do it a second time and a third. This falsehood of the tongue leads to that of the heart, and in time, it depraves all its good dispositions. What does that mean? It means that it's been observed that to tell an untruth, to exaggerate, to make a false claim, it's a cancer. One lie begets another, and it's a malignancy that grows over time. And that, folks, is how a cover-up is born. That's how a Massachusetts state trooper says in whispered tones to his friends when he thought no one was looking or listening, how he would make a case, how he would make it cut and dry, no matter the truth, how he would make sure to put, quote, serious charges on the girl. In other words, pin it on the girl.
Okay, so did you guys look up who is the quote from? Where is the quote from? So the quote is from Thomas Jefferson to Peter Carr, and supposedly it's in Paris, August 19th, 1785. And this is relative to Jefferson quotes. And one of the quotes that he is quoted is saying is, it is of great importance to set a resolution, to not be shaken, to never to tell an untruth. And there is no vice so mean, so pitiful, so contemptible. And he who permits himself to tell a lie once finds it much easier to do it a second and a third time, till at length it becomes habitual. Sorry, habitual. He tells lies without attending to it, and truths without the world's believing him. This falsehood of the tongue leads to that of the heart, and in time depraves all its good dispositions. So Alan Jackson was quoting Thomas Jefferson, obviously in a paraphrasing way, a little more modernized way, but that was the theatrics that he brought to the table. Good old Tom Jefferson. That's a good
You
one.
may ask
Alan.
yourself, how does this
Good
happen?
job.
How could this happen? It's 2024. Surely people aren't going to come to this courtroom, this hall of justice, and lie to us. Just give us
Okay,
false
the fan is
information.
still
They
going.
wouldn't do that. They wouldn't try to cover up the truth. The Alberts, the McCabe, Higgins, Lank, Michael Proctor, Yuri Buchanan, Brian Tully. You don't have to wonder if they would lie to support their narrative. You need only wonder how many times they did lie. Over and over and over, they and others were caught deceiving you. Big things, small things, it didn't really matter. They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered. They'll show you a video and tell you left is right and right is left.
How do you feel about that? The butt dial was answered by the butt that's supposed to be in motion with their spouse. Why is your phone in the bed? Like, really?
They'll magically turn 3 pieces of plastic into 5 right before your eyes.
Anything is
And
possible.
even when they're caught with their own lies, they won't blink, they don't sweat. They'll just look you in the eye and demand, pay no attention. You folks look the other way.
Watch what boiled eggs do
No.
to your body.
No. No.
Have you ever noticed how you could easily eat through?
No. I don't notice it before.
Ladies and gentlemen, there was a cover-up in this case, plain and simple. You'll surely say to yourself, I don't want to believe it. I don't want to believe that can happen in our community. But sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Come close, offer him help, offer him a gift. Have secret friends and family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches. Monitor police activity. Get rid of evidence. Get rid of your dog.
Here's the thing that really gets to me about the evidence is under more normal circumstances, under most cases, or just cases I guess I have been able to take the wind of, the prosecution is like, celebrate is God. It has no skin in the game. There's no dog in the fight. It's not biased in any way. You have to believe the evidence. The evidence is here. This is the celebrate. Here's the data. Here it is. Here it is. Here it is. And this case is like, okay, look, don't worry about the celebrate data because I understand, he was moving around up and down, stairs or a hillside, but that's not real. Don't worry about that because that didn't happen. And ignore the fact that she's, her phone has now connected to the web, the Wi-Fi at 12:30, and clearly he's in motion around that time based on his, his Apple Watch. Pay no attention to that. No. Don't worry about any parts of that. When does data all of a sudden no longer become science? And then the reconstructionist of all time from the FBI is like, yeah, no, you don't here. Uh-oh. Are they making? Oh, wait, the jury. Okay, we've got to see the jury. Hold on. Looks like the jury's coming back. Uh-oh. Your Honor, no, we're not aware of anything. What happened? Oh, no spinny wheels.
Cited last owner of
Karen.
I hope you can hear. The jury is in, or the judge is at the bench. Let's see what's going on.
You are unmuted.
Okay, thank you.
Thank you. You see the closed session.
We're back on the record on 22-117, the Commonwealth versus Karen Reed.
Okay. All right. So, counsel, you're aware of our note from the jury. Dear Judge Cannoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict signed by the foreperson. So I want to hear from counsel your view on whether there has been due and thorough deliberation. So let's start with the Commonwealth.
It's only been 18 hours.
My answer would be no, Your Honor. This simply hasn't been sufficient time yet.
And what does the defense say?
We believe that there has been sufficient.
All right, so I'll hear from both of you in more detail. Mr. Lally, I will hear you.
Your Honor, the jury received this case just earlier this week. They've had slightly shortened days, and I'm not in any way, shape, or form suggesting that they haven't conducted their due diligence in regard to their deliberative process, but I would submit that it is far, far, far too early in their deliberative process to even consider giving them any kind of Tui Rodriguez instruction or anything close to that. Furthermore, what the note doesn't really indicate affirmatively that they can't come to a conclusion. It just says that they haven't come to a conclusion through their deliberative process at this time. They're not asking for one, is what I would say.
All right, thank you. Ms. Giannetti, I'll hear you.
I would disagree with Mr. Lally's characterization of the note. The word exhaustive is the word I think that's operative here. They're communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and they're at an impasse. This is a case where the jury has the legal instructions. They've only really asked one question, which was to try to get a report that they were not allowed to get. And I think the message has been received that the evidence is closed. They won't get anything more. They've been working essentially nonstop over the last 3-4 days. We're approaching the weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is the jury should be read the Tui Rodriguez model instruction and go from there.
Okay. All right, so you all know that it is within my discretion, I decide. So a case that has been, it's a long case. This is our 4th day of deliberations, but Tuesday was a short afternoon, maybe 2.5 hours. Wednesday, they left early because of an appointment. Yesterday was also shortened a little bit, and this note arrived with less than 3 hours of deliberations today. So the length of the trial, the length of the deliberations, I know the case we heard from 74 witnesses. There are 657 exhibits, very complex issues in this case. I'm not prepared to find that there have been due and thorough deliberations at this point. So I am going to send them back out. We'll bring them in and we'll do that now.
Mm-hmm. That makes sense, but it's not really, you don't want to test that water as the defense, because what if it's just one person that's holding out and they're like, look, I want my weekend. I want to get out of here. So you don't want to test it and then turn around and that one person folds before the weekend because they're being forced to stay. It does let them know that there's someone that is at least one person that is on their side. But what if it's only just one person? Like, that's the hard part. You don't know. You don't know. Stop zooming in on her. Good God. Law and crime. I thank you, but I don't. Stop zooming in on her. You're not going to be able to read her mind, whatever you try. And the evidence, what do you think? The evidence is confusing if you okay. Jury's coming in. She's going to give an instruction for them to try it, keep trying. But put it in the chat. What do you think the evidence shows? Is it confusing? Is it cut and dry to you? If so, what does it show you? Guilty, not guilty. That misdemeanor stuff, that extra lesser charges are confusing. I don't like those, but
Back in session, you may be seated.
I don't think the attorneys explained it well. in
Right.
closing.
So, jurors, I'm in receipt of your note. I'm writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict signed by your foreperson. We all know how hard you've been working. Lunch will be arriving shortly. When it comes, I'd ask you to clear your heads, have lunch, and begin your deliberations again. So, or continue your deliberations. All right? So I'm sending you back out.
Is this judicial
All right, for the court,
gaslighting?
please.
We know you've been working hard. We know it. 5 minutes ago, Your Honor, you just said that they really got started. Oh, that was like a heart attack. I just knew we'd get the scoop. Oh man, no scoop. No scoop. Jury is still in
Thank you.
deliberation.
Be seated. Court is still in session.
All right, so the note has been marked for identification, and we'll see you all either at 3:30 or when you get a phone call.
All right.
Okay. So just in case you just now came in, we're gonna get off the fan. Hey fan, thank you, fan. You're so helpful. We appreciate the fans. Okay, unmute me. Thank you. Appreciate you. We'll go back to what we were doing before while we were on verdict watch, but we just heard from the jury that they. I don't need you in my back in my ear. We just learned that the jury is having a hard time coming to a unanimous decision. They felt like they have looked at all of the evidence. And Your Honor's like, we had 70 some odd witnesses and 90 something pieces of evidence here. No, go back. That's kind of like deflating, but not. You can look at it both ways, and it's really interesting. I would love Alan Jackson to like get on here and be like, tell us, okay, so we're happy or we're kind of concerned. Which one are you, Alan? Are you concerned or not? Because, like I said, it could just be one juror. It gives them hope to know that they are not in agreement that she's guilty, because you have to be unanimously in agreement that she's guilty, but you also have to be unanimously in agreement that she's not guilty. And so consequently, they don't have that agreement on either side. So there is that solace to the defendant, Karen Reed. But of course, like I said, if it's just one juror that's, kind of being resolute and saying, no, I am resolved, I do not have convincing evidence to convict this lady of murder, then what? What does Friday look like to you? Don't you like going home on Fridays? Don't you think these jurors like going home on Fridays? They've been sitting in this room for 30 days, a month and more, because they had to go through the jury selection process. They have been on this case for a long time. Don't you like your Friday? I think they like their Fridays. I think they like their weekends. And I don't know, pressing them to go back might not be in the favor of Karen Reed. I hope that I don't want them to be a hung jury either, because I really feel like the evidence is very clear. I really do. I feel like the evidence is clear. I feel like the testimony and the outside influence of those that were involved is a problem. But if you take people who have nothing to do with Boston, you take, the experts that were from the FBI. We know FBI. I don't know that they know that if in case they did pay close attention to one of the Alberts who blurted it out, but nonetheless, that's not in evidence. But they know that there's some other type of hearing. There's some other event that transpired outside of their viewing. And consequently, These other experts became hired by a different entity, not the Commonwealth and not the defense. That is a completely unbiased third party review. In that expert set of testimony, to me, that has the highest weight. In addition to just the common sense of what is the evidence, just the lacerations, the markings on Officer O'Keefe's arm, that's the evidence. To me, everything else is conjecture. Everything else is forcing the round peg into a square hole. That is why I have a definitive response. But the jurors themselves feel like no. So they're going to go to lunch, and hopefully lunch will be better. No Subway. We want real food, Your Honor, because you're making us stay. Isn't that if only Alan can be like, can I order them some steak and lobster so that they can enjoy their lunch, so that they can have like the most creme de la creme lunch? Can we get some clam chowder out here? Some real good food. A good po' boy or a lobster roll or something really good and delicious. So no Subway. We need real good food for the jurors. If Alan can make that happen, all right, Toot Sweet, let's go. Toot Sweet. They might come together collectively, right? Yeah, right. But Alan, we're gonna give you some shine and go back in time and look the other way based upon your closing.
Destroy your
But guess what? Someone on that jury is not looking the other way. Someone on that jury is saying, no, the evidence is not conclusive. Something is wrong. Something does not align. And as we can tell, there's a lot of something.
phones. Destroy your SIM card.
Yeah.
For the investigator, decide on a narrative early on. Don't go to the crime scene. Don't take witnesses in for questioning.
I think he misses an opportunity there, because it's not just destroy your SIM card. I think he said clone your phone, but like not even clone your phone. Like give screenshots. No metadata. And I think now almost every layman person understands metadata, in the sense that there is data that exists that can tell you if you have compromised a photo, if you have compromised a text message. We've learned that much, at least from Deb V. Heard, that there's metadata, there's data behind it to let you know how many times this has been manipulated. Has it been manipulated at all? So to just do a screenshot should be alarming to any juror. Like a screenshot, that's not evidence. We need the metadata. We need the data behind
all
it.
Witnesses together. Ignore witnesses who don't fit your narrative. Allow friends and family to contact those same witnesses. Don't record interviews. Write vague and false police reports. Omit witnesses' names. Omit witnesses' interviews altogether. Don't photograph the evidence. Don't conduct any forensics. Don't document the evidence. Don't document the logs. Don't create any logs whatsoever, and don't maintain a chain of custody. Keep all the evidence in the hands of one person, and then manipulate that evidence, including videos. Don't turn over videos. Invert videos. Turn 4:16 p.m. into 5:30 p.m. in affidavits. Turn 3 pieces of taillight into 5 pieces of taillight. Delete 42 minutes of surveillance footage. Hide personal relationships. Make this case cut and dry.
This is where visual demonstrative would be helpful, because I think Lally does the timeline. That's finally like, oh, thanks, Lal. Great. It's at the end. I have no idea what the timeline was before then, right? You had to be writing your own timeline to have an understanding as to what the Commonwealth's theory of the case was, as to when this happened versus that. But also to critique Mr. Jackson, not that he's, perfect, but also not that he's flawed. It's just to have better, hindsight. To come into the courtroom in this juncture and not really have the demonstrative to show us, here is all the evidence that shows that this is a problem. exhibit this, evidence number this, the erasing of this phone, cloning it, only doing screenshots, the other person getting rid of their phone, the this, the that. Giving all of that as a collective verbally is impressed upon the jury. Like, yeah, that's a lot of things. But then Lowley comes after and goes, but we can explain that all away. And how much of that makes an effect. So I would have liked the visual to show just all the piling up, because the issue is not whether, if it's not a cover up, which I kind of don't like that he hammers down that it's a cover up. It could very well have been poor policing. It could very well just been like, nope, we got our suspect, so we're done. We know exactly who it is. We don't need to work hard. We don't need to do another thing. And that's the problem. You have to do it. Regardless if you think you have the suspect, you have to do a full investigation so that when you present to the jury, when you present in court, you can say we did full investigation. No matter where we turn to, all the evidence continues to be pointed back to this one suspect. That's how we know that this is the person who has done it. If you don't do that, then, faith is lost in your discoveries. This would have been a great time for Alan to have had the visual demonstrative to show the jurors, yeah, cover up, no cover up. It's a whole lot of right. It's a whole lot of non-investigative procedures, whole lot of improper preservation of evidence, a whole lot of missteps for personnel who is supposedly 30 years, 20 years, this extensive history in the field and in their job description, allowing witnesses to do things you just don't normally do. Mall cops, security cops know that you don't interview witnesses in the same room, that you separate them and interview them at 2 different times. So, all right, Sergeant, and
ensure the homeowner, quote, never sees any shit because he's a Boston cop. But most importantly, pick your patsy and pin it on the girl.
And then on a girl,
It's not that it could happen.
it did happen.
It's that every single one of those things I just mentioned did happen right in front of you.
And that's the problem.
But this sort of injustice can't happen in a vacuum. So what about the prosecution? What about the Commonwealth? What does it look like when the government picks a narrative and then tries to form a prosecution around the narrative instead of the other way around? Looks a lot like this.
Mm-hmm.
If you don't have actual evidence, just throw every single thing you can against the wall to see what sticks.
Mm-hmm.
Drag her through the mud and make sure you attack her character. And that's what you saw in this case. The Commonwealth spent much of their time and resources trying to vilify Karen Read. They desperately resorted to calling witnesses to talk about Karen Read and John O'Keefe's arguments. They even stooped so low as to call the children and put them through this ordeal. All to say that John sometimes got upset because Karen was too kind, too nice, spoiled them too much. Their arguments illustrate.
I think that is so real. Yeah, so real. Like, for real, tell me something. You are the parent. Like, if you have a 2-parent household, you're the parent who is always buying the gifts, and then the other parent is like, stop buying them everything. They need to earn it. The grades are not good. They can't just get everything they want just because of this or that. That is such a real argument. It's such a real relationship argument. It's not even like relationships in trouble. It's just a real one. Like, you definitely going to have 2 separate viewpoints when it comes down to how and when you are spoiling or you are doing something important for your children or the children that's involved. So that's really a real argument. I think the Commonwealth's argument of infidelity and all of the particulars that he's somewhere else, I think it's really kind of big. I think they're making it bigger than it really is, because Even Karen is like flirting with another guy. Like she's like trying to get him jealous. He's getting her jealous. It's like, whatever. We're not really married, so we can do what we want to do. Attitude, you know. So, but that is a more substantial argument of this is why they had a fight versus they had a fight because of the clothing of the kids and the spoiling of the kids. It's not a real fight. That's not even a fight. That's like okay, all right, thanks, John. Won't do it again. Here, take this. Right. Here.
Traded what
That's it.
anybody could imagine is a normal
Simple.
set of ups and downs for any couple.
So normal.
Even on January 28th, they talked it out, they communicated, they worked out their issues, and they had a nice, affectionate evening out with their friends. And you don't have to take my word for it. Pull the tape, as they say. Look at the videos. C.F. McCarthy, Waterfall.
Oh, no. No. We will not. No, we won't. We don't need any commercials, okay? We are the commercial. We are the commercial on jury duty waiting for jury verdict, okay? We're jury verdict watch. We are the commercial. We do not need commercials, please. Okay, the fan is still up, so no movement except the fan goes round and round. That's all the movement we have right now. Back to the closing argument. Let's go.
What are the words that every single person who testified in this case used about Karen Reed and John O'Keefe that night? Getting along, no issues, good mood, happy, affectionate, even lovey-dovey. No issues, no toxicity. They were a loving couple right up into the time Karen Reed dropped him off and he walked into 34 Fairview. If an argument with a loved one is a motive for murder, folks, we're all in trouble. Speaking of which, what is the evidence that John went into the house?
If an argument is the motive all by itself, if that's it, especially that argument, we are all in trouble. You know how many arguments you have? I want you to count how many arguments you've had this morning. Okay, it's morning for us in LA. So if you are like, no, it's noon. Okay, so all right, East Coasters. For this morning's time, however, before noon, how many arguments have you had with your loved one? I know at least 10 of you are going to be like, well, at least like 2, because when I made the first statement, she got mad and thought I meant it was something else. And then we argued about the fact that I wasn't taking her point of view and her into consideration. And then I had to apologize. And I really don't even remember what the argument was about. But yeah, we had that. Like the kids were laid out the door to get to camp. And I had now this is my thing. My husband drove, bless his heart. The kids were late getting to one of the campsites. And so he drove to the marina. He drove over to the beach to drop him off. He comes home and my son needs to go to work now. And he's like, okay, so are you going to take our son to work up the street? I'm like, no, I'm going live. What are you talking about? It's verdict watch. We're on verdict watch. We don't move. We're stuck. Like we're invested now. Life has to stop around us because we're going live. Verdict watch. That was not an argument, but he looked at me and was like, okay, I'm gonna let you do your thing. I love you. Bye. I'll take him. But I could tell it was almost an argument. It was almost one. We could have had one because I was not moving.
The Commonwealth will tell you, undoubtedly, no, he never went in the house. And they'll point to certain witnesses who they say didn't see him go in. Well, the question you have to ask yourself is, can you rely on that? First, these are all people who are related to or committed to the Alberts in some way or another.
Right.
That all-powerful Canton family, it's easy to say, I didn't see something, because how can that really be challenged? Some actually may not have seen John walk into the house. They were in the kitchen, as you recall, from Nicole.
And drunk.
Third, at least one witness, Brian Higgins, forgot his narrative, at least for a second, and he admitted a man did, in fact, come into the house. And when he was caught and asked to describe that man, he had to. It was a little bit vague. You remember what he said. He was tall,
Mhm.
dark hair. That was a
Mhm.
telling slip of the tongue by Brian Higgins. But what's the real evidence of the unbiased data, the data that's not connected to the Albert family? How about John's Apple Health data? It shows that at 12:21 a.m., an important time, John arrived. That's established by the monotonic time clock that you heard about in this trial that was on his phone, and that represents a huge problem for the Commonwealth. It shows that he took 80 steps and ascended or descended 3 flights of stairs at that time.
Right.
And that makes perfect sense, doesn't it?
Yep.
It matches. Walks
Makes
into the house, goes directly to the basement. There's your 80 steps and your descending flights of stairs. The big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs, wasn't climbing on top of the car. So they'll tell you, wait, don't look at the Apple Health data. Look at this other thing called Waze. But Rick Green explained that if you apply.
As funny as it is for Alan to be like, he wasn't climbing on top of the car. Don't give them other stuff to think about. They might say, oh, was he climbing on top of the car? Was the fight like for real, like a big deal? And she took off and that's why he fell and hit his back of his head. Like, don't give them that, Alan. That was funny, but don't give them that.
Apply the 3-minute offset that is built into that monatomic time. It aligns perfectly.
TikTok keeps trying to tell me that.
I don't care. Oh my gosh. You know what? Everybody in the world right now is trying to figure out what's going on with this verdict, right? So, or they're going back and they're looking at the evidence again. And we are examining the evidence and we are looking at the closing again to see what could have Alan said, what could have Lolly said differently, what has, pressed upon the jurors. They don't get to do that. They don't get to see the evidence the way we get to see it with the trial. They have the visual evidence. They get to hold it. But as a result, we're getting the what are these the massive commercials.
They don't want you to see that
Because everybody
Pay
wants to
attention.
know. Oh, wait.
They want you to look the other way.
Here. I don't know if you guys can hear, but I can't hear. I'll try this again. Oh, yeah. What's wrong with the sound? We were doing so good, Alan, until somebody tried to sell us a. We got it now.
Car. So they'll tell you, wait, don't look at the Apple Health data. Look at this other thing called Waze. But Rick Green explained that if you apply the 3-minute offset that is built into that monatomic time, it aligns perfectly.
Mm-hmm.
They don't want you to see that. They don't want you to pay attention. They want you to look the other way.
Mm-hmm.
But even more importantly, at approximately 12:32 a.m., someone holding John's phone takes another 36 steps and travels 25 meters. Why is that so important? Because by 12:32 a.m., Karen Reed was gone. She had already left the location. She left at 12:30.
Mm-hmm.
Trooper Garino told you that Karen Reed's phone connected to John's Wi-Fi at what time? 12:36. It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview over to One Meadows.
Okay. Mm.
She was gone by 12:30, and John's phone was taking 36 steps and logging 25 meters at 12:32
Mm-hmm.
after she left. So
Right.
don't be fooled. John walked into that house, after which Karen drove away, and the scientific data all prove it.
Right.
But
Just
also,
data.
Ryan Nagel
science.
and Heather Maxson prove it. In addition to the Apple Health data, Ryan and Heather both independently testified that they passed Karen's SUV as they drove away after talking to Julie, and Karen was alone in the SUV. John was not with her. He wasn't in the car. He wasn't standing outside the car. He wasn't sitting beside the car. He wasn't laying on the ground beside the car. He was nowhere in sight. There's only one other place that John could have been.
He on top of the
And
car?
that's in the house. Exactly where the Apple Health data places him.
Mm-hmm.
So it all fits. And Ryan was right behind her, remember, staring at her taillights, undamaged, brightly lit. That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. You'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over again from 12:29 to 12:50. She was very specific about that.
You know the problem with Jennifer McCabe being the star witness? She's not the detective, right? And her being the star witness is she's the only one who knows everything. like what? She's like, yeah, at this time it happened, at this time it moved up, at this time it went again, and this time, and then, oh, and Carrie, I was there for every part of her testimony, and then I don't even know if she accounts for it. I think Carrie is the one who says, while they're in the car, she's like, hey, remember you dropped him off. You dropped him off at the Fairview house. Why would you think that? Does anyone ever, that would be like one of my major quorums with her testimony if I was a juror. Why would you come to the conclusion that she dropped him off if he never came in the house? If he was never in the house, why would you think that he dropped, that Karen Reed dropped Officer O'Keefe off if he never came in the house? That gives some wind to the fact that she knew, or it purports that she knew. It looks like she knew. It seems as though it is reasonably to the evidence that she, in fact, was aware. And they were driving around at 5 o'clock in the morning, or whatever time it was, that Karen Reed dropped him off at Fairview. Because Karen Reed was like, no, I left him at the waterfall. That's how much he remembered. And McCabe is like, no. Jennifer McCabe is like, no, you dropped him off at the house. I saw you drop him off at the house. How'd you see that? All you say you saw was that the car was there and the car moved up, but no one ever came in the house. That's what you say on the stand. But during the time that they're looking for him, you remind Karen that she drops him off at the house. But we're supposed to believe that he never went inside. All right.
That time frame. But we know that the SUV was gone from 34 Fairview by about 12:30.
Mm-hmm.
Had to be in order to connect to the Wi-Fi at 12:36. So unequivocally, Jennifer McCabe was lying about watching that SUV, and it makes you wonder why.
Yeah.
And to add to that deceit, she was also blatantly lying about the calls to John's phone. You remember that colloquy back and forth. She said that every single one of those calls to John's phone during that time was a butt dial. How are those lies connected? And why are they connected? Jennifer McCabe knows. Was she butt dialing John over and over? Or was someone looking for John's phone that went missing?
Rooms loads a complete serving of fruits.
I keep telling them I am the only authorized commercial. We have to tell them, stop stuff. We want everything for free.
Let's talk for a second about what actually happened.
Speaking of free, we're free. So only thing you got to do is like, share, and subscribe, and it's all free. So no need to buy this commercial. No products being sold. It's all free.
Time leading up to everyone going to 34 Fairview, Brian Albert, Brian Higgins show up drunk at the waterfall. They had been drinking in the afternoon. You know about the flirtatious texts that were sent between Karen Reed and Brian. Higgins was clearly pining over Karen, but for her, the flirtation had ran its course. It was done. She was happy and committed to John. You could see that interactions with John that night. You don't have to guess. Brian Higgins, however, you can see in his actions, he wasn't quite so satisfied and he wasn't done. His text message, well, meaning, what the hell, Karen? What about me? Seemed aggressive, seemed annoyed. He didn't like being ignored. That was pretty clear. So he's 5 or 6 whiskeys deep into the night by this time, and she continued to ignore him. Then oddly, Higgins, who doesn't know John all that well, seems to want to coax John to 34 Fairview. I draw your attention to the waterfall tape if you want to take another look at it. It's at the 11:57 mark, between 11:57 and 11:58. Take a look at that tape. He's just about to leave. Higgins is just about to leave. He points over at John and he motions for him. Come on, come with me.
Okay, so Alan is from LA. I don't think he's used to the jurors not having their pen and paper. They don't have their notebooks. Stop giving them times to look. They're not going to be able to remember these times. So I think that's an issue relative to this. So in hindsight, because hindsight is 2020, looking back, it would be much more prudent for Alan to just say, don't you remember in the video where XYZ happens? It's right after this point. It's somewhere 5 minutes in, about 5:36. But to say, take a look at 11 this, take a look at 5. No one has this in their memory. They've lost all numbers. So give them the facts. Give them the info.
And then at 12:20, he texts him, you coming here? This is a person he doesn't really know and didn't really talk to that entire night. Ask yourself, why was Higgins so insistent that John go to 34 Fairview that night? And then there's that sparring and fighting that he and Brian Albert were engaged in.
It wasn't.
Of all the things they could be doing,
This is the problem.
this is what they were doing. Just
This is the problem. You lose trust in the jury when you're trying to make that happen. When you are the honest one between the two and you're not trying to overdo the evidence, the jurors are like, oh yeah, I believe what you're saying. But when you're like, they're sparring and practice fighting, they weren't. It's probably been a minute since horseplay was in your life. It's probably not your thing. But just go back to high school, right? This is the friends of all friends. They're just horsing around. It's not that big of a deal. But to try and make it a big deal, problem for the jurors. Well, it can be.
before John O'Keefe walked into that house at 34 Fairview.
Very good. Yeah.
We know that once John actually did walk in the door, it's about 2 steps, 4 feet or so, 2 steps for an adult male to reach that basement door. Remember, everybody was gathered in the kitchen. That's what Nicole Albert said. And every single witness agreed that at some point, Brian Higgins and Brian Albert left the group and went to another room. Where did they go?
Mhm.
Where did they go together?
Mhm. Where did they
Another
go?
important point.
Where did
Chloe
Chloe go?
Was not upstairs.
Where did the dog
Brian
go?
Albert slipped in one of his in testimony that he provided.
Poor dog.
Quote, I was watching Chloe downstairs, monitoring her because of the other people in the house. She's not good with strangers. Remember that testimony. So what happened next? We absolutely know that John was in the house. The data, Ryan, Heather, they all established that. We know that John ascended or descended stairs. We know that Brian Higgins and Brian Albert excused themselves. How long does it take to have a crossword? How long does it take to have a fight? How long would it take for Brian Higgins to say to John, you know, your girl's been texting me. A push, a punch, a fall, pull Chloe off his arm, and now it's done. What is that? 5 seconds? 10? Doesn't take long at all. And then the panic sets in. It wasn't intended to go that far, but what's done is done. And then some very, very odd things start happening at the Albert household. Very odd indeed. What do we know? We know through the testimony and key swipes that Brian Higgins, very oddly, goes directly to Canton Police Department. Why would he do that? After a night of drinking and partying, why go to CPD when you're drunk?
And
What was so important there? He couldn't even get his own story straight. First, he said it was administrative work. Then he said he was moving cars. Then he said it was a factor of both. Is it both? Was it neither? Or was he there to gather intel? Ask yourself, why go? But the odd things keep piling up, and here's another. Chloe was the Albert family pet. Not only did she appear to be gone from the house that morning on January 29th, nobody saw her there. Even Jim McCabe admitted, yeah, I didn't see her there. But they actually got rid of the dog altogether.
Yep.
Within months of this incident, the dog was gone, out of the house, rehomed, never to be seen again. This was a dog they had had for 7 years.
That never
Also
happened.
a dog who had a bite history. Why was it so important to get rid of that dog? Was there something about the dog they did not want law enforcement to find out? Recall what Dr. Russell said. She's seen up to 1,000 animal attacks. In her expert opinion, John's right arm, those injuries are from an animal, quote, most likely a large dog. And Dr. Russell's testimony, I'll remind you, was undisputed by any witness for the Commonwealth. But there are more odd and unexplained things. After a night of drinking and hanging out and partying, after being together for the entire day at 2:22 a.m., Brian Albert decides to call Brian Higgins. That call was missed, but 17 seconds later, Higgins calls Brian back, and they speak for 22 seconds. Now, that call is odd and suspicious enough, and just in and of itself, the fact that the call was made. But what's even more incriminating is that both men, both of them, lied about the calls happening. They both claim astonishingly that those calls are, you probably say it with me, they're butt dials. Amazing.
But dials. Those are the dials of this case. All of the butt dials. So, okay, what I wanted to know from you is we heard what the Dr. Russell said relative to Officer O'Keefe's injuries. What do you say? What do you say relative to his injuries? And let's just, I mean, there was no real injury to his whole body. There was injury mostly to his arm and his head. So just the arm, which I was trying to get the arm. Okay, I think this one will show us. Okay, just the arm, people. Just want to think about the arm. Where is okay. Alrighty, let me show you where we are here. And I want to thank CBS Boston for the arm. Looking at the arm, this is not the best picture. We had a better picture in trial, but looking at the arm, those injuries, what are those injuries to you? What are they to you? Oops. And sometimes that's the purpose. That's the thing. You don't get into, well, this particular expert said this particular expert said that, because a lot of times the experts don't always have to agree. You can get into experts that don't necessarily it just so happens that both experts did. It just so happens that the coroner agreed that this was not a car. She could not say it was a homicide, and Guess what? She wasn't the normal coroner. She had been in rotation. So that was her new day. That was her new time. So consequently, maybe it was good she was on the scene, because maybe we'd have a coroner that would have agreed with the officers and said, oh, yes, most definitely it was a murder. Oh, yeah, he was killed. But that's not what happened. Not in this case. She looked at the arm. She looked at all of his head injury. She looked at his whole body, and she determined, no, it did not happen from a car. This is not as a result of a car. So did the defense's expert, Dr. Russell. Dr. Russell said it's a dog bite. What do you say, chat? What is it to you? What are those?
But Albert and Higgins take it a step further. Not only did they claim that they were making calls as butt dials, but they were answering calls as butt dials. And Higgins seemed awfully defensive about that call, didn't he? Remember on cross-examination when I was asking him, can you have a conversation in 22 seconds? He unequivocally said, no, that's impossible. It's not reasonable. You can't do it.
Okay, if you're watching the YSL trial, Young Thug trial, you know those prosecution attorneys Hilton and ADA Love do not agree with Trooper Proctor or what was that, McKay? No, Albert, Brian 1 and 2. I don't remember, A and B, whichever one it was. They got up there and said, no, 22 seconds is not long enough to have an exchange of conversation or communication. Okay, we have motion and eliminates right now going forth for 2-second communications, 3-second statements. So you mean to tell me a whole conversation can't happen in 22 seconds? Okay, try to convince Georgia of that, because they don't believe you. They're cutting down testimony down to the seconds, okay?
Let's test that out. Hey, did you make it over to Canton? Yep. Haven't been any calls. Nobody knows a thing.
Good.
All right, don't talk to anybody until we talk again. Okay, fine. And by the way, come back over. I need help moving something heavy.
It's about 16.
How long did that take?
16,
15
17.
seconds, maybe? But the odd behavior isn't done yet. 5 minutes after that call that we just talked about, Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold. That was at 2:27 a.m. That timeline seems to fit, doesn't it? And it fits a very telling and a very clear story. That search became a focal point of the Commonwealth's entire case. This case was starting to look a lot more like the defense of Jennifer McCabe than anything else. That's probably because there is no innocent explanation for that Google search at 2:27 a.m. None. At the end of the day, clearing away all the confusion of the Commonwealth's experts, we're left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That search was at or before 2:27 a.m. And then it was deleted. So what else was going on at or around this same time when all this suspicious activity was happening at the Albert house and the McCabe house? 3 minutes after that search and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street in his snowplow. And he told you that there is no body laying on the lawn at 34 Fairview at 2:30 in the morning. Importantly, he didn't just simply say he didn't see a body, he wasn't paying attention. He said there was no body there. He knows the property, he knows the owners, he's grown up with these folks, he passes by all the time, not once, not twice, 3 passes. There was no body on that lawn, period, at 2:30 a.m. And what other suspicious thing happened that night? By 3:30 a.m., someone moved a Ford Edge in front of the very area that would obstruct the view
Say
of
it
where
isn't
John's
so.
body would ultimately be discovered. Who's the only person in this case that you've heard about with a Ford Edge? Brian Albert. Remember, as you're thinking about this, the basement at 34 Fairview is serviced by a bulkhead. It's a quick and convenient door to the backyard. And that backyard is serviced by a side fence. And that side fence is easily accessible to the front yard at the side of the house. Which side of the house? The side where John's body was found. And by 6 a.m., John's body was, in fact, now outside. While this flurry of suspicious activity was going on with the Alberts and the McCabe's, what's happening with Karen? All she knows at this point, think about it, at approximately 2:21, she dropped off John. He walked into 34 Fairview, and that's all she knows. She knows nothing else that
12:21.
was going on. So what was she left to think? He goes in to check the party out, but all of a sudden he's not coming back. He's not responding. Minutes start to pass. 1 minute turns to 2, 2 turn to 10. Where is he? Why isn't he responding? She's sitting in the cold, dark, freezing outside in the car. Naturally, she's perturbed. Being perturbed turns into being peeved. Being peeved eventually turns into being pissed. By 12:30, Karen's mad. She's left 34 Fairview to make a point, but she's still texting and calling. What could she reasonably be thinking at this point? What's going through her mind? 12:33 turns into 12:34. I can't believe you do this to me. 12:34 turns into 12:35. Where is he? Why aren't you answering, John? 12:35 turns.
Okay, just a little update relative to jury watch, because that's jury verdict watch. That's what we're doing, even though we're kind of recapping a little bit of the case at the same time. The jury did not necessarily have a question. They had a statement, a note. It was read into the record, which was basically that they felt like they could not come to a unanimous decision. They felt like they had exhausted their efforts in that regard. That was at 18 hours of deliberation. That's 4 days. The prosecution, well, Commonwealth stood up and stated that, it's kind of soon. We're still only in the first week. This is too early to say you're a hung jury. And consequently, that was Lally, and then Yannetti stood up for the defense and argued the fact that the jurors did in fact state that they had exhausted all options when it came to the evidence, and that they tried to come to resolution, and they have not come to a unanimous decision to the resolution. So consequently, he tried to argue against it, but the judge felt like, no, we're going to have lunch anyway. So eat lunch, brought the jurors in, eat lunch, clear your heads, calm and woosah, get back into it this afternoon. So that was the resolve that the judge took. And it's kind of reasonable, but it's scary nonetheless, because if you are the defense, you have some inclination that they don't have a unanimous decision. So consequently, there's at least one person on your side. But you're not able to confirm that it's more than one person. You only know that it's one. And so it's like gamble that they go back there. You're crossing everything. Everything is crossed at this point, because you're like, if nothing else, come back and be hung in the long run. But at the same time, it is just week 1, day 4. I thought they'd have a resolve come the next day, Wednesday, middle of the day, towards the end of the day of Wednesday. I really did, because not guilty is a very seemingly easy conclusion to come to. But for 12 minds to come to the same conclusion is a lot harder than you think, right? I'm just dealing with my own mind. I can come to a conclusion very easily by myself. But when you have 12 people that have to come to the same conclusion on a unanimous stance, that is a difficulty. And that is why you have 12 jurors, to give different perspectives. That's where we are in jury watch. They're going to take lunch. We're now 19 hours of deliberation. They're most likely having lunch right now. And we're just letting Alan remind us of all of the, inconsistent evidence.
It's at 12:36. Jesus Christ. I'm calling and you're not answering. Where are you? Pick up the phone.
That's reasonable.
Most people
That's very reasonable because if you're not supposed, okay, so what's the lady Carrie? I think it was Carrie who said, um, Karen Reed is a glorified babysitter. That could very well, though it was snarky and it was, rude, it's just a factual statement in her mind, probably. She's probably just stating what she knows. It could almost feel like that's what Karen felt. Like she was just a glorified babysitter, that the relationship didn't have a genuine connection, or that the connection was on and off. It wasn't a consistency. Whatever her opinion is, in that moment, she's like, here we are. I'm sitting here with the kids and you're out, gallivanting, you're out hanging out. And she comes to the conclusion that he's out with a girlfriend. He's out doing nefarious activities against their relationship. Not that he's dead, not that she left him in the cold, not that he didn't go inside the house, not that he's hurt, at least not in the beginning. She didn't often realizing that he's not responsive. She becomes more concerned because she's like, wait a minute, if I tell him I'm leaving these kids by themselves, he's going to respond to that. And he's not responding. It's reasonable.
But there's still no answer. There's still no response.
Yeah,
By 12:37, she's getting furious. She does not know that something has happened to John. She does not know that. So she leaves the first angry voicemail. Illustrates frustration, aggravation, all the normal responses
Nobody can tell time.
anybody might have.
She just
You and I might have.
She just
But little did she know. The next open voicemail has Karen parking at John's garage after she gets home. You can hear her heels clicking across the garage floor. For all she knows at this point, John's just drunk. He's been partying. He's hanging out. Just forgot about her, blowing her off. But John's.
Oh no, I did not mean to do that. That does coincide a little bit with her afterthought because I'm 12:37 is when she's like sending him these messages and like, you just dropped him off at the party. Why did you think he'd be coming home within 10 minutes? Within 5-15 minutes, kind of a short period of time. But her mind, if we maintain with what is reported at the time, Carrie Roberts says that McCabe reminds her, you dropped him off at Fairview. Her mind is, I left him at the waterfall. And if you remember, she walks out the waterfall by herself. She gets in her car. He ends up coming, I think, or maybe he comes right as she walks out or whatever after some time. He ends up going with her. But in the beginning, she walks out of the waterfall by herself. And that's where her memory stops relative to what she's done with him. That's kind of scary. Like she was definitely, she was intoxicated. That's what I can say. I don't know if she was so intoxicated she deserves DUI and all that. That's not my job. But what I know is if you can't remember that you took him somewhere else, something has impaired you. And so consequently, but that's what her thought was. I left him at the waterfall. So now it's 12:37. It makes sense for her to be texting him like, what the heck are you doing? Because to her, he's coming straight from the waterfall. Even though she should remember that, in fact, she dropped him off at, where was it? The Alberts. Okay, so let's find where we were.
Ask yourself, why go?
Why go where?
But the odd things keep piling up, and here's another.
What?
Chloe was the Albert family pet.
Okay, we got to Chloe. We're past that, so let's see about this time.
In the car, naturally, she's perturbed. Being perturbed turns into being peeved.
This is where we are.
Being peeved eventually turns into being pissed.
Without touching buttons.
By 12:30, Karen's mad. She's left 34 Fairview to make a point, but she's still texting and calling. What could she reasonably be thinking at this point? What's going through her mind? 12:33 turns into 12:34. I can't believe you do this to me. 12:34 turns into 12:35. Where is he? Why aren't you answering, John? 12:35 turns to 12:36. Jesus Christ. I'm calling and you're not answering. Where are you? Pick up the phone. But there's still no answer. There's still no response. By 12:37, she's getting furious. She does not know that something has happened to John. She does not know that.
Doesn't remember.
So she leaves the first angry voicemail. Illustrates frustration, aggravation, all the normal responses anybody might have. You and I might have.
Yeah.
But little did she know. The next open voicemail has Karen parking at John's garage after she gets home. You can hear her heels clicking across the garage floor. For all she knows at this point, John's just drunk, he's been partying, he's hanging out, just forgot about her, blowing her off. But John's still not responding, and as the minutes tick by, Karen becomes increasingly upset. Those are the voicemails that you heard. How could he do this? Why is he ignoring me? Why is he ignoring the kids?
Mm-hmm.
Those are the thoughts bearing down on Karen Reed as she sat in an empty house late at night by herself. Ladies and gentlemen, she did not know what had happened to John. But within the next voicemail, you quickly learn what she was thinking and what she was feeling. Now it's 5:23 a.m. She's woken up, she's realized that he hasn't come home and he hasn't responded to a single text, not a single call. And anger quickly turns to panic and abject fear.
She is breathing heavily. And some have criticized her to say that her facial expressions are void of emotion, or they feel like she's staring them down or whatever. I don't think so. I think we have to remember we're in Canton, we're in Boston, we're in Dayton. This is Massachusetts. So to some degree, there is a hardness in just the everyday expression, and I don't think the jurors are feeling like she's staring them down. To me, she's breathing heavily. She's trying to stay composed, and that's how I see her. I see her trying to hold in her emotions, hold in her outcries. And if you take the video and the audio of how loud she is emotionally just outcrying when she's noticing John O'Keefe's, the officer O'Keefe's body, you can realize for yourself, her holding in her emotions is probably hard because she couldn't do it then. Obviously, it's much more time has passed, but it's still emotional. It's still prevalent. It still matters. Yes. Okay.
She's so distraught, she reaches out to him again. John, where the fuck are you? She says through tears and desperation. And at 6:03, the question was answered and her worst fears are realized when she finds his body laying, dying in the cold in Brian Albert's front yard. You heard her. You can feel the grief. You can feel the raw anguish. You could see it. You don't have to wonder the emotional journey that Karen traveled that night. You can see it in the video. You can hear it in the audio. From the time he left her and walked into 34 Fairview and she called, she reached out 53 times. She called him 53 times before finding his body. Think about that. The Commonwealth wants you to believe that she murdered this man. Mm-hmm. And then after that murder, she called him not once, not twice, 53 times. Mm-hmm. It makes no sense. What does make sense is that she emotionally moved from anger, then to panic, then to grief. So back at 5:07, when she began her search looking for John, she backed out of the garage, and what would happen next would change the entire course of this case. As she backed out of that garage, she hit John's Traverse and cracked her right rear taillight. Folks, the Commonwealth has one job to do in this courtroom. It's an immutable responsibility to provide you with the truth. That's it. Not to win the case, but to seek justice and to do it through the truth. Ask yourself, did you get that truth from the Commonwealth? The Commonwealth continually tried to tell you that video showed that the SUV came close to John's Traverse, and it took us showing you the video to unequivocally establish that Karen hit that car and cracked her taillight at 5:07. You can almost hear an audible gasp in the courtroom when we finally showed you the actual video. You can see that tire move.
Right.
I'm only going to show you one series of exhibits during my entire
Great
closing,
exhibit. Great exhibit.
but it's that important. And it's this. Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here.
Oh my gosh. I was just getting ready to pause for the tail light, and now
Oh my gosh, this is so comfortable.
oh my gosh, put some clothes on. No, just kidding. Okay, pay attention to that. I mean, pay attention to that commercial. I'm the commercial, not him. Okay.
That taillight is cracked.
Okay, so before Jackson tells us what to think, look at the video, look at the pictures. What does it tell you? The best thing that John O'Keefe, Officer O'Keefe, did, aside from loving his niece and nephew and being there for them and his friends, the friends that the O'Keefe's and the other set of friends who just couldn't hold their composure when talking about him. That was so emotional, such a beautiful sight. So his genuine friendships, his love for his kids, him adopting his niece and nephew and loving them as his very own, caring for them in a way to prepare them for life lessons, to keep them in motion. Finds a girl. I don't know how they come about. I'm not even telling the whole story. Doesn't even matter. They have their ups and downs. They're trying to work it out from one day to the next. Because on the 28th, she's questioning the commitment level. He's expressing he's totally committed. It's nothing. She's overreacting. Okay. The next day, they go out. They have a great time together by everyone else's accounts. This has happened. One of the best things he has done is to put in that Ring camera for his driveway and for one of his doors. Too bad it wasn't on the other door. But one of the best is that he had this Ring camera, because if it were not for this Ring camera, Karen would not be able to prove that she hit his car backing out of his driveway in frantic motion to get to him, to see where he could probably be, to find him, to figure this all out. And we would not have these pictures to see as evidence of what damage there actually was to the back of her car. There is exactly the type of damage that was described by the was that the tow truck driver or the Sally Port? I think whoever it was. One of the guys said it was a small hole. One of the troopers, I think it was, said it was a small hole, and Carrie Roberts said it was a small hole, and it didn't make any sense for her to think she hit him, because she's like, what is this hole? Did I hit him? What is this what happened? She's trying to come to conclusions, and the girl's like, girl, you're tripping. This is like the smallest of damage. Shut up. No, you did not. Let's go find him. He's on somebody's couch. He passed out. God, so wish that were true, right? Wish that were true. But one of the best decisions is to have the Ring camera, because now you can look for yourself and you can tell me, is that what the prosecution gave you? Is that what the officers and the detectives said was the evidence to her car, the damage to her car? Is that the evidence they reported? No. They reported a whole piece missing, a whole damaged taillight. But yet, we can see, because of O'Keefe's Ring camera, we can see, based on the light, there's really just one small little piece missing.
but it's not completely damaged. And if there was any question in your mind about the level of damage to that taillight at 5:07, all doubt was extinguished. When Dighton Police Officer Barrows walked into this courtroom, he's a sworn officer. He's not associated with Canton. He's not associated with the Alberts. He's not associated with the McCabe's. He doesn't know Michael Proctor. In other words, he doesn't answer to any of these folks. He's an outsider and he's completely independent. And his words were the following, quote, "That taillight was not completely damaged. It was cracked. A piece was missing, but not completely damaged." Take a look at this photograph and tell me.
Yes, tell us.
Which one looks like Officer Barrows' description?
Which
The one on the
one?
left or the one on the right?
Which one? Now, the one on the left obviously is the one that the young lady put back together in reconstructing what it was to make sure that all of those plastic pieces were in fact relative to a tape that does in fact fit Karen Reed's car. However, the picture on the right is what they took as a picture of evidence to say she hit him. This is the damage that was caused to the car, and he falls back into his head and dies based upon the car hitting him. This is their evidence. Well, that doesn't comport with the evidence of the Ring camera, which has, no dog in the fight. And that's where Alan's like, look the other way. Don't look at the Ring camera. Look at our pictures, because we're telling you what Trooper Proctor said. We're showing you what they collected at the time. But the truth of the matter is that one little bitty piece on the left, right? It's not small. It's not that little enough compared to the whole piece in and of itself. It's about 15%, 20% at most of the whole tail light. That's the piece that's missing, because that's supposed to be red, but it's not. So why believe that this one on the right is actually the way the car was damaged because of hitting Officer O'Keefe? That does not align evidentiary. The evidence does not align, not in my opinion anyway. I don't.
The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that. That's what it looked like before Trooper Proctor had access to the SUV.
That's a great point. That's the way Kerry Roberts saw it. That's the way that officer saw it. That's the way Karen Reed saw, it was a piece missing. Everyone saw a piece missing. But now all of a sudden there's a whole tail light missing. Yeah, okay, buddy. And then one of the things that I said just in the very beginning, just watching it, watching the trial independent of the channel, that on the right-hand side, that seam looks like there was something that has jammed into it and pulled it out, much like a crowbar would do. That's the way I see it. I can't prove any parts of it, but that's just I felt about it. And I always felt like it feels like someone has taken or tried to take this thing out and didn't realize they went too far versus just getting the pieces. And I don't know if it has anything to do with when they were taking out the light to determine if the camera was working, if that's the reason why it looks like that seam is broken open. But to me, that looks weird. They never addressed it in trial, though.
And you have an independent police officer telling you so. You'll recall that after John's body was discovered, Lank, a very good friend of the Alberts, walked into Brian Albert's house and had an off-the-record meeting with him. No one's ever going to know exactly what that meeting was about, what they discussed, because that interview, in this case, it wasn't recorded. It wasn't memorialized. But we do know that shortly thereafter, the Canton Police Department was recused from the matter entirely. And the case was assigned to one Michael Proctor. You have to believe that when the Alberts found that out, they thought they hit the lottery. They thought they hit the lottery. What are the chances? The department where my brother works
Oh my gosh, you don't need filler. You don't need it. Be cute as you are. I needed coffee though. I had to warm up my coffee. Sorry. All right, Alan.
And with that, Michael Proctor didn't draw a thin blue line. He erected a tall blue wall.
Huh.
A wall that you can't scale. A wall that Karen Reed certainly couldn't get over. A wall between us and them. A place you folks are not invited. Actually had possession of the car before the first pieces of taillight were ever discovered at the scene.
Oh wait, hold on.
.416 when he finally had to tell the truth or some version of the truth. Those first pieces of taillight were not found until after 5:45 p.m. That is the very fact that Michael Proctor was trying to hide by those falsified affidavits, saying he didn't seize the car until 5:30. But that wasn't Michael Proctor's only manipulation of the investigation. What about Brian Lochran? You met him. Michael Proctor did his level best to not just hide evidence, but to hide human beings from you and from us. Michael Proctor was informed that the plow drivers were out that night. There would be a witness, potentially along 34 Fairview, at the exact times in question. Even Michael Trotta expressly told Michael Proctor that 34 Fairview had in fact been plowed that morning, and by whom. Proctor not only did not interview Brian Lochran, he never disclosed his name in a single report. He hid him. This is a witness who was literally on 34 Fairview at the time in question where a body was found on the lawn. Wouldn't you want to get the truth from an eyewitness? Wouldn't you want to seek that out? Not if you're Michael Proctor, a close friend of the Owls. If it were up to Proctor, you literally never would have heard of or from Brian Lockren. That's a scary prospect. I want to touch briefly on the additional physical evidence, or some additional physical evidence presented by the Commonwealth in this case. You'll recall Christina Hanley. She established to a scientific certainty that the glass on the bumper, which was told to you in opening statement, was going to have something to do with this case. The glass on the bumper was going to match that cocktail glass. She told you unequivocally the glass on the bumper did not match the cocktail glass. They came from two different sources. The glass on the bumper has nothing to do with the cocktail glass. So that glass on the bumper had to get there somehow. It didn't get there by being broken from the cocktail glass. See the point? It had to get on the bumper somehow. It didn't jump up there by itself. And what's really interesting is that there was one piece on the bumper, only one, that matched something else in the case. It was a perfect match to a piece of glass that was supposedly found at the scene. Who do you think had possession of that matching glass? Michael Proctor. So the glass on the bumper had to be placed there. And the only person who had anything close to matching the pieces that had to be placed there is Michael Proctor. You do the math. That leads us to the magic hair. The Commonwealth spent a lot of time bringing in experts about mitochondrial DNA and maternal DNA lines and comparative analyses, and all that sounds really great and really sciencey, except for the fact that it just doesn't matter. Why? Because you would have to believe that that little hair, tiny, tiny little hair,
even if it did,
barely perched on the side of that SUV survived nearly 75 miles of a raging blizzard outside.
Listen,
that would,
even if the hair did survive, even if the hair was stuck on there because of the snow, so what? Karen Reed's defense, not she didn't know him. Karen Reed's defense is not they weren't friends. They didn't have a relationship. They never met. She knew him and they met. There's no bloody hair. That's the ultimate issue, because they lived together for all intents and purposes. They stayed over. She stayed over there for nights on end at times. So, you know, he got in the car that night. He's been in her car before. Maybe she got it washed that day because it was a very clean car inside and out. She does well at keeping it clean. Okay, or she did, because I don't think she ever got the car back. But nevertheless, his hair being on the outside of her car, it's almost not that big of a deal because there's nothing that says the hair is bloody. It's not like a patch of his head or anything that's extreme. It's not a fingernail, because supposedly it hit his arm. Even if it was a hair off of his arm, there's no blood there. So that connection doesn't really solve the question. It doesn't answer the question.
would be a magic hair indeed. But magic hair means nothing.
Magic or not,
DNA means nothing. And that's because the hair was from somewhere else. It certainly was not from a motor vehicle incident at 34 Fairview on January 29th. That hair was placed there.
Maybe.
Watch what boiled eggs do.
I don't care about boiled eggs.
To be found all over that SUV, inside, outside, the exterior, the interior, everything he touched would have had his DNA
It's
on
not
it.
blood.
Here's what's actually important about that DNA. No DNA was found on the interior of that taillight. The taillight that they now claim crashed into his arm and shattered.
That makes sense.
No blood was found anywhere on that taillight or any taillight pieces. And no tissue was found anywhere on that taillight or any taillight pieces. But we're to believe that that taillight literally exploded on John's arm at 25 miles an hour
And cut it up.
1,000 pounds of pressure.
Cut it up. But didn't
We
we
talked
get
about the
blood
evidence
in the
doing
tail
very
light?
funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that you saw. How many videos appear to be somehow manipulated or altered? Just about every single one of them. Look at the video of the
Right.
Sally port. Let's take that one, for example, that grainy one. It's missing the exact time that would show the condition of the taillight when it was pulled in to the Sally port. Pretty important time, wouldn't you think? Did someone not want you to see what the condition of the taillight was at that exact time? But the good news is there's a second video. It's much clearer. And it's from the same time frame. We didn't get that one for about 2.5 years into the investigation. Literally, it was after the trial started that one was turned over. And this is important. The Commonwealth introduced you to a person by the name of Yuri Buchanan.
FBI.
They presented video showing what was clearly the right side of the car.
Yeah.
They asked questions about the right side of the car. You'll recall, Mr. Lally asked Sergeant Buchanan, did you or Trooper Proctor ever go at or near the right side of that taillight? And while he was asking the question, what appeared to be the right side of the car was looking at you. The video was still up. Buchanan paused, turned earnestly into the microphone, stared at you and said,
And lied.
never. We never went anywhere around that taillight.
I know, that's right.
While he was showing you the right side of the car. And that trick might have worked until we got up to cross-examine him. And only then, on the second day of his testimony, did he have to admit that the video was actually inverted.
Right was
It was
left.
backward.
Left was right.
And it was cleverly inverted at that. The timestamp had the proper orientation, which means that timestamp had to be removed, the video inverted, and the timestamp placed back on it, which means that was done intentionally. That was not a mistake. And when caught in that obvious fabrication, Buchanan doubled down and said, it's exactly the same. You remember that back and forth. It's exactly the same, he said, as if we're stupid.
Right.
Is it exactly the same?
No.
Or is it exactly opposite? Ladies and gentlemen, you were lied to. There is no other way to say it. It's inexcusable. It's abhorrent. But it's also a paradigm of everything that the investigators have been willing to do in this case. Lie, obfuscate, manipulate, alter. And when they're caught, they just excuse it away. Doesn't matter. It's the same thing. What's the big deal? Just look the other way. And don't forget, Buchanan is Proctor's supervisor. And he was in that little group chat where Karen Reed's naked photos were being searched for. You know the saying about the apple falling from the tree. Ladies and gentlemen, we haven't even started talking about the taillight yet. You'll recall that at the very beginning of this case, you were introduced to no fewer than 5 CPD officers very early on who searched the scene. None of them, not a single one.
I don't know
found
if you
any
remember that,
taillight
Alan. I don't
material
remember
at the scene.
point.
0. Stephen Seraph, Sean
one
Good,
to
Stephen
10 or
Mulaney, Michael Lank, Paul Gallagher, they were all there. They were all walking right around there. They were all looking. They were searching with their eyes. They were searching with their hands. Some said they were searching with their feet. They even used tools, a leaf blower. Not one piece of bright red taillight material was at the scene, not a single piece, but incredibly, over the course of the next 3 weeks, according to Michael Proctor, 47 pieces of taillight material would end up being found, some of which were the size of a salad plate.
Oh.
The CERT team shows up later on January 29th, and according to O'Hara, the
Yeah,
first few
dessert
pieces
plate.
of taillight were found about 5:45. And here's some interesting testimony that you heard. Who else was there? Who did O'Hara say was there? Well, he said his team was there. We certainly expected that, but then he said there were others. These other mysterious figures, some from Canton PD, some from the Massachusetts State Police, that he could not account for. Heavy coats,
Hey,
masks,
Peggy.
hats.
Hi,
Even Lieutenant
how you
O'Hara could
doing?
not tell who was who, but he did note Canton police officers were there who were unaccounted for. Massachusetts state troopers were there unaccounted for. And during that search that was overseen by Trooper Tully, Proctor's supervisor, 3 pieces of taillight material were found. That's super important. I want to concentrate on that for a second. O'Hara said all 3 pieces were in an area about 12 inches square. That's an area about as big as your dinner plate.
TikTok keeps trying to tell me that I have secret.
So I don't know if you heard Peggy. Great, because I was getting ready to take a pause anyway. Peggy, I don't know if you saw this, but earlier the judge got a note from the jury, and the jury said, "We have exhausted ourselves. We don't come to a unanimous decision." And the prosecution got up, Commonwealth got up, argued that obviously it's not enough time. And then so the defense got up and said, wait a minute, it is enough time. They said they've exhausted all their efforts. The judge agreed with the Commonwealth, which is Lally, and sent the jury in, brought the jury in to let them know, have lunch, take a mind break, and then get back to it. Thank you for your service, but stay of service. You're not released yet. So the jury is still in deliberations. We're in hour 19, though that's probably their lunch hour, but it's 19 hours that they've been deliberating. So good to see you. I hope all is well. Hopefully, you're enjoying your horseback riding at this time. And just a little update to the verdict. We're still on verdict watch. The jury felt like they were not unanimous. That only indicates that at least one person does not believe unanimously. Does not mean, that they are 6 and 6 or 50-50%. So we don't have any assurances as to how they're going to come out of this matter. But right now, they are not unanimous. All right, we're going back in to look at, what is this, gentleman? We're going back to the closing remarks of the defense so that we can just refresh our memory as to what the jury may be going over and thinking about right now as they deliberate. And like I said, good to see you here.
Was a shoe about 1 to 2 feet from that was a clear piece of plastic, and a few feet away from that was a red piece of plastic. So we have red, clear, and red over the span of about, added up, probably 10 or 12 feet. Ladies and gentlemen, both of those things cannot be true. Somebody taking liberties with the facts. Then Lieutenant Tully comes to court and makes this big grand gesture of opening all these evidence bags. These 2 evidence bags in particular represent exactly what we're talking about. Those 3 pieces, red, clear, red. They're marked, they're sealed, they look official. They're not Stop and Shop bags, thank God. At least they've moved up from that.
Let's praise them on
They
that
even
one.
got evidence tape on them. Who knew? There's evidence tape around here. So this must be real evidence, right? It must be real evidence in this case. And after making that big theatrical display, he opens up the bag with the red pieces and he pulls 2 pieces out. That's okay. Put the 2 red pieces together. Good so far. Then he opens up the second bag under Mr. Lowley's questioning. And you remember, he hesitated just a second. He opened that bag and pulled out 1 piece of clear plastic, then pulled out a second piece of clear plastic with no explanation as to how that could have possibly happened. And he quickly returned all 4 of those back into the bag, sealed them up, and we're done for the day. The next day, I asked about that evidence again. I asked him to open up that bag with the red pieces, and he did the same thing. Pulled out 2 red pieces of plastic. I said, you'll recall this, I said, look deeper, look closer, sir. Pull everything out of that bag. Would he have had I not suggested it? And then he pulled a 3rd piece of red plastic out of the bag. So miraculously, Trooper Tully's 3 pieces of plastic became 5 pieces of plastic right before your eyes.
Yeah.
Ladies and gentlemen, the forces at play that multiplied those pieces of plastic inside those evidence bags are the same forces at play that multiplied the pieces of plastic at 34 Fairview. Think about it.
So Alan's projection at this time, his foresight or his conclusion relative to the pieces of plastic, there are arguably reasonable thoughts that can explain multiple pieces of plastic. It's in paper bag. So it could have been 3 pieces that something, squished it, turned it into 5 pieces easily. However, he does a good job at pointing to the fact that this helps his narrative, which is interesting once again for the defense to come up with a defense of the opposite narrative as to what has happened. I think he's just using his prosecutor skills, and he's like, listen, this is a possibility. I kind of don't like that he hammers so hard on it. He's better at it than I am. I can tell you that. He does a better job than me. So he chooses to, in fact, use this, because that's the point. You use whatever evidence is there to the advantage that you can. You explain away what needs to be explained away, and you show the jury how this evidence can fit into the narrative. And his narrative is, it's a cover-up. Look the other way.
Let that sink in for a second. How easy is it? That's not sloppiness. That's evidence manipulation. That's how over the course of 3 weeks, those pieces of plastic go from 0 to 3 to 5 to 47. Ever increasing in size with porn.
I just got your message. Oh, I did this doggone thing again. I pressed the wrong button. I just got your last message, Peggy. I feel you. I do and I don't. So I literally had my own opinion of innocence, not guilty. And I figured that would be by Wednesday. That's how I interpreted the necessity to come to a conclusion. But understanding you get 12 people, they have to come to the same conclusion. So it's not it's not a majority rule. It has to be 12 people collectively agreeing. So it has to be unanimous. And the only solace that I had before hearing that they were not unanimous this morning, before they had the announcement, I was like, you know what? I'm going to be a little more kind about the jury not having a verdict right away, because that means that they're looking at the evidence. They're contemplating what they actually heard and saw, versus Trooper Proctor, who was like 12 hours in. Okay, yeah, the girl did it. And so every piece of evidence we get from here on out is just going to prove that the girl did it. Like, we're not even going to investigate this. So consequently, I'm like, okay, at least somebody is giving Officer O'Keefe real consideration for what has happened to him, and trying to understand the evidence and follow the evidence as it is presented, and not just go direct to the narrative. But then they came out and they said they don't have a unanimous agreement. And I was like, darn. I really don't. I also don't like the lesser included charges, like the manslaughter charges. I'm like, oh my goodness, this is so confusing. Like, just think if you have no legal background and you're like, Your Honor, I don't think she killed him, but she was drunk. But does that mean she killed him when it says because she was drunk? Like, the jury form is confusing. But yeah, not guilty would have been very simply understood, in my opinion. I'm just holding out hope that they won't have a hung jury, or that the other thing that I don't want them to do, if they do have to have a hung jury, I'd rather they have a hung jury than they turn around and that one person or so, or two persons who are on the fence about it, and they're like, no, we can't find her guilty, that they don't get discouraged because now they're not allowed to leave to go, to go home, because they told the judge that they couldn't come to a unanimous decision. I hope that they don't lose their resolve. Not because I don't want her to be found not guilty, but because the evidence, in my opinion, does not support her to be found guilty. That's why. I have no other dog in the fight, just relative to my views. All right, people. Did it again. I pressed the wrong button. So let's see if we can find Alan. Where was he?
If you sleep on your side, I bet you hate your pillow.
No, I don't hate my pillow. I just hate this commercial. Okay, thanks. Appreciate it.
Interview on January 29th. That hair was placed there.
Okay, we're past hair, so we were a little further.
Your piece of plastic, and a few feet away from that was a red piece of plastic. So we have red, clear, and red. Okay. Over the span of about, added up, probably 10 or 12 feet. Ladies and gentlemen, both of those things cannot be true. Somebody is taking liberties with the facts. Then Lieutenant Tully comes to court and makes this big
We're all
grand
taking
gesture
liberties,
of
Alan.
opening all these evidence bags.
We're liberal
These two
people.
evidence bags in particular represent exactly what we're talking about. Those three pieces, red, clear, red. They're marked, they're sealed, they look official. They're not stop and shop bags, thank God. At least they've moved up from that. They've even got evidence tape on them. Who knew? There's evidence tape around here. So this must be real evidence, right? It must be real evidence in this case. And after making that big theatrical display, he opens up the bag with the red pieces and he pulls two pieces out. That's okay. Put the two red pieces together. Good so far. Then he opens up the second bag under Mr. Lowley's questioning. And you remember he hesitated just a second. Opened that bag and pulled out one piece of clear plastic. And pulled out a second piece of clear plastic.
All right, we're still on the fan.
As to how that could have possibly happened. And he quickly returned all four of those back into the bag, sealed them up, and we're done for the day. The next day, I asked about that evidence again. I asked him to open up that bag with the red pieces, and he did the same thing. Pulled out two red pieces of plastic. I said, you'll recall this, I said, look deeper. Look closer, sir. Pull everything out of that bag. Would he have had I not suggested it? And then he pulled a third piece of red plastic out of the bag. So miraculously, Trooper Tully's 3 pieces of plastic became 5 pieces of plastic right before your eyes. Ladies and gentlemen, the forces at play that multiplied those pieces of plastic inside those evidence bags are the same forces at play that multiplied the pieces of plastic at 34 Fairview. Think about that.
Yeah.
Let that sink in for a second.
Maybe.
How easy is it? That's not sloppiness. That's evidence manipulation. That's how over the course of 3 weeks, those pieces of plastic go from 0 to 3 to 5 to 47. Ever increasing in size with every single search. Now, knowing all that, ask yourself the looming question, who had access to that taillight, the cracked taillight? Who was it? Go back and watch the Sally Port video. I'll give you the timestamp, 5:37. And see it for yourself. We know that Trooper Proctor, with binder in hand, walked by himself. Once we corrected the video from being inverted, you can see that he walked back by himself to the right rear taillight where nobody could see what he was doing. Higgins' own key swipes put him in the Sally Port that same afternoon and evening. And then the Sally Port video magically skips and Chief Berkowitz appears right next to Proctor at the back of that vehicle in the same spot, and they walk out of the Sally Port together. Where were they going? Remember O'Hara? Unidentified troopers in Canton Cops were at the search at 34 Fairview. How hard is it to drop a piece of plastic? We spent a long time talking about the compromised and altered and tampered and manipulated evidence. And now I want to switch and talk a little bit about the true facts in this case, because you did hear some true evidence and true facts. The Commonwealth presented about 67, maybe more, witnesses and expended 30 plus days of trial and 9 weeks of your life. Maybe we're in the 10th week.
10 weeks.
For what? It should be relatively simple, right? The Commonwealth claims that Karen Reed pulled up to 34 Fairview, John got out of the car, she reversed into him and hit him, and then she drove home. That's 4 facts. It's just 4 facts. That's all it is. What evidence do they actually have to prove that that SUV ever hit John? The answer is none. They don't have any. There's no evidence whatsoever that Karen Reed's vehicle ever struck John O'Keefe or that Karen Reed ever wanted to strike John O'Keefe.
Which is intent.
In fact, every single piece of material evidence in this case unequivocally proves the opposite. John went into that house. That SUV was not damaged by hitting John, and John's injuries did not come from being hit by a car. That's what the evidence actually shows. The Commonwealth knows that, and they've known it for a long time, and Proctor knows that. And because of that, the Commonwealth just resorts to character assassination and talking for weeks on end about the snow. Let's talk about what the real evidence actually shows.
Lally does not like that part.
Let's talk about the truth.
What was snowing?
Concerning John's injuries first, the Commonwealth's own medical examiner, Dr. Scorti-Bello, could not conclude that John was hit by a car. Think about that. And she would not even say that it was a homicide.
Oh,
She told you without any dispute in this case,
No.
quote, evidence pointing toward one manner of death is no more compelling than evidence of a competing manner of death, end quote. Her words, not mine.
Mhm.
She went on to say it's just as likely that he was punched and fell backward. His injuries are consistent with that. In fact, in her expert opinion, his injuries are consistent with a physical altercation, as she testified, but they are not, in her words, not classical injuries from an auto pedestrian accident. That by itself is reasonable doubt.
And
But the evidence and the truth goes.
hold on. I come off of there for just a second. I feel like that piece right there kind of expresses a great deal to me as if I was the juror in this scenario. Just taking that piece right there, there's reason to think there's an altercation. Maybe one of the Bryans or the young man Colin just gave him one punch, but he was so inebriated that he fell back, hit his head, or something. I think they said it had to be harder than the ground to cause that type of fracture. So maybe they hit him with an object and then gave him a punch. And they thought it was just a regular fight. There's not anything that's regular about using an object. I'm not minimizing it, but I'm just trying to like figure if that was the scenario that you just felt like you hit someone maybe twice, you're expecting that they're gonna get up and live when they get up. Unfortunately, we know that whatever put John O'Keefe on the ground, 'cause they want to proclaim it's a car. We don't have evidence that it was a car, but whatever put him on the ground, he was in a coma during that time. He couldn't get up. He couldn't move, and he ended up freezing to death. So had anyone had the compassion and the humanity and the first responder instincts to say, he's not getting up right away. Let me go see what's going on with this guy. He might still be here today. And I think it's very reasonable that he could have been in a fight and all you thought it was going to be was a couple punches and it'd be done. And you think he'd walk up the street and go home or and you know, screw him because you're mad at him. You don't expect that he's going to die. But he dies. And instead of being honest and you know, man enough and of credible worth in saying, I did this, I apologize. I just thought we were in a fight. I didn't notice that, you know, he wasn't moving. I thought he was moving. I figured he would get up and walk away. Instead of having that gumption, you turn it into the girlfriend did it. That's crazy. Like, why? There's no evidence to that, but yet you make that the evidence. That's a huge problem. And that's why when they recuse themselves as the entity overlooking the case, because there was too much potential for conflict of interest, too much to give the defense, you know, like we're doing something of wrongdoing, nefarious activity, they should have stayed out of it. And they should have turned it over to someone that was actually going to do the proper investigation. The ME just so happens not to be of the town. She comes in and she properly does her ME review and analysis and comes to the conclusion, this looks more like a fight. I don't know, this is a homicide, but it looks more like a fight. It doesn't look like anything like a car. I can't conclude that. So no, I'm not going to just put anything down because that's what you want. And then you get Proctor and everyone laughing in the chat like, oh, that's a risky move. You should have went down there and convinced her. You should have had a conversation with her because she's new, because she's not from around here. Oh, Peggy, okay, so you agree. You think he was hit and he fell and hurt his head, and for whatever reason, they tried to cover up. Yeah, just for whatever reason. Just whatever. But the problem is now covering it up, you now put everything you've ever done on the line. So if you were the best investigator in Canton, every case now becomes a subject of inquiry because wait a minute, did you cover it up for this case over here? Did you improperly collect evidence over there. You know, is it the big deal? You got an FBI investigation now. So is it always worth? I always say, is it worth it? And I never think it's worth it, because if you can lose your license, if you can lose your way of providing for your family, it's not worth it. Just right. Tell the truth, right. That's why that Thomas Jefferson statement that Alan does in the beginning about, if you were willing to lie once, you're willing to lie a multitude of times, is so prevalent, because it is it's poor character. You know, lying is an example of poor character. And I believe the rest of what he say was it's a representation of the heart, and in time it deprives all of its good disposition. The heart is now poor character, and the person is now hardened. Their heart is hardened, and they don't have the ability to have good in them, because if they become a habitual liar.
Goes far further.
Based on Tom.
We introduced you to not one, but two thoroughly credentialed medical examiners or medical experts, Dr. Sheridan and Dr. Russell, both of whom said John's arm injury is consistent with an animal attack.
Which makes
Dr. Russell studied, diagnosed, and treated up to 1,000 animal wounds. She's an expert in animal wounds, and she was unequivocal. Those wounds are from an animal, likely a large dog, which means that John was attacked inside the home where Chloe was. There is no other possibility. And Dr. Sheridan, for his part, with thousands of 13,000 autopsies under his belt, decades of experience as the chief medical examiner, who's triple credentialed in anatomical, forensic, and neuropathology, he told you that John's injuries are inconsistent with a motor vehicle accident or incident. They're consistent, however, with a physical altercation. In layman's terms, the science proves John was beaten. That also is reasonable doubt and should end this case. But the facts and evidence don't stop there. Two of the most highly educated and highly qualified engineers you'll ever meet, Dr. Dan Wolf and Dr. Andrew Rentschler, mechanical engineer and a biomechanist. They reviewed this case. They did testing, they did analysis, they evaluated the case scientifically. They were not hired by the defense, not by the Commonwealth. They're completely 100% independent of any party in this case. And they were equally available, by the way, to the Commonwealth. They could have called them.
Aye. Thank you. No, thank you. I do the commercials. Thank you so much. Appreciate you not. Yeah.
They could have called them.
They could have, but they did not.
They explained that John's injuries were not caused by being hit by Miss Reed's SUV, and that the SUV was not damaged by coming in contact with John O'Keefe's body. That should end the inquiry right there. Both sides of the equation. From a physics, engineering, and biomechanical standpoint, they established that John O'Keefe was not struck by Karen Reed's vehicle, period. And that is yet another fact that establishes reasonable doubt and should put an end to this case. So instead of calling the ARCA experts, which they had available to them, the Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember his testimony. I think I'm being kind when I say that Trooper Paul's analysis lacked credibility. Trooper Paul lacked the experience, the education, the training, the background, and the knowledge to not only render opinions on these issues, but to even understand the issues themselves. He makes the absurd claim that John was hit on the elbow area of his arm by a taillight. He was spun to the left in a pirouette. His arm stayed on the light long enough for the shards of plastic to explode around him, scratching his arm, even though he was wearing long sleeves, then projecting him 30 feet to the left, but not before making a stop to hit his head on either the curb or the pavement, before coming to his final resting place with his unbroken phone tucked neatly under his body. It's nonsensical. It borders on laughable. Compare that testimony to Dr. Dan Wolf
All right,
Dr.
Betty, appreciate
Andrew Rinchler.
you.
Both PhDs in engineering, both top of their field in accident reconstruction,
Feel better.
both published peer review articles on the issues. Both men are highly sought after by the likes of national sports leagues and the United States Department of Defense. And these men are unrivaled in accident reconstruction.
Mhm.
What did Dr. Rinchler say before he left the stand? This was even under cross-examination. He said that the physics and the science don't lie. His words were, you can't deny the science and the physics. John wasn't hit by that car, period.
Right.
The Commonwealth cannot explain John O'Keefe's injuries. They can't explain his head wound. How did he get the head wound if he landed on snow-covered grass and dirt? And by the way, before Mr. Lally gets up and says it, because I know he's going to, there is zero evidence before you, zero, that cold grass and dirt turns into ice or turns into concrete. Zero. They can't explain the injury above his right eye, that laceration. They can't explain his nose. They haven't even tried to. They can't explain the injury to his tongue, the laceration on his tongue. They cannot explain the injuries to his back, to the back of his hands, the bruises, and certainly they cannot explain the injuries to his right arm. But maybe most importantly, they cannot and haven't even tried to explain the lack of injuries on John's body from the neck down.
Exactly.
Nothing. He was pristine. Not a bump, not a bruise, not a fracture, not a broken bone. Nothing to suggest that he was hit by a 7,000-pound SUV going 25 miles per hour. And what of that right arm?
And of course, Lally gets up and talks about it being a side swipe versus his perspective is that the car doesn't just fully back all the way into John O'Keefe, that it side swipes him from his arm aspect, which I guess is this way that he's supposed to be hit. Okay. So how is that an intent then? How are you proving that this was intentional based upon that? And then on top of that, the ME says that he had bruising around his eye that looked like a punch. Then he had the big knot on his hat, which of course we found out later. I thought it was from a bruising from another hit, but what the ME, the doctor says, is because of the fracture in the back of his skull had moved up, it created a different kind of bruise and then different kind of knot on the front side of his head. But nevertheless, the ME's conclusion of all of the factors of his encounter, or his bruises and his different scratching and bumps and fractures, all conclude to the ME that it was an encounter with maybe a fight, an altercation. And the Dr. Russell and the other expert that the defense brought in has the scratches looking like dog bites. Well, there was a supposed dog expert, I cannot validate it or not, so I'm not going to show it, but was an expression that the dog bites really looked superficial. This is what Dr. Russell even testified to, which they not proclaimed, but what is it? It's an example that this is a dog that is not a police dog, because police dogs are taught to bite in certain ways, which is called the bite and hold. That's their ultimate bite technique. So usually it's punctures, or maybe there's and they're deep wounds that are typically administered by police dogs. This was what this gentleman said. I'm just recounting his statements. I don't know for sure because I don't deal with police bites. I've never been bitten by a dog, thankfully. But was a dog or an animal, a bear? I don't know. But it definitely wasn't a car. Like, there's nothing underneath the car that gives any wind to those like patternized scratches. So it's not erratic scratching. It's not erratic abrasions. They look like they have a pattern to it, a set of at least 3, in my opinion. And I thought they were nails and then one bite. Dr. Russell said she saw more than one bite. That's her expert opinion. She definitely is expert in that. And all that to say, when you get this on your desk, Prosecutor Lally, when you get this whole file on your desk, you still come to the same conclusion that Karen Reed did it. It's almost as if no one can see anything else because it means failure or something's wrong with them to come to any other conclusion unless they're outside of Canton. But inside of Canton, it's like you have to only see that Karen Reed did it no matter how the evidence plays to you. We're almost done.
According to the Commonwealth's best and brightest, Paul, John absorbed the entirety of the collision, the whole collision, with that 3.5-ton SUV entirely with his right arm, launching him some 30 feet. But amazingly, the arm suffered no break, no fracture, and didn't even get a bruise. So how are those injuries properly explained? The evidence is simple. John got into an altercation. He was punched. He tried to defend himself by putting his hands up. He may have even scratched his own nose by putting his hands in front of his face to defend himself. His hands were bruised and covering up.
5 minutes, Mr. Jackson.
Thank you, Your Honor. As he continued,
that's a good one. 5 minutes.
He got hit, punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got a hold of him, and the dog was pulled away. Every single injury is answered. Every single injury is explained by that.
Say
goodbye to you. We only have 5 minutes of Alan, so stop interrupting. Do me a favor, like, share, and subscribe. As you know, I'm the commercial around here. Whatever's selling, you don't have to buy it. We're free. Like, share, subscribe is the only payment we ask for, and it's voluntary.
Ladies and gentlemen, given what we know about the facts and the physical evidence in this case, the actual truth in this case, how did this happen? How did we end up here? We ended up here because of relationships, insider trading, playing the who you know game, and building a tall blue wall, which takes decades and generations. But the real question is it going to continue? Will this festering malignancy that allows a lead detective and his supervisor to gloat and sneer while looking over naked pictures or looking for naked pictures of the woman that they've targeted, will that continue? And the answer should be not if you have anything to say about it. Michael Proctor is the lead investigator in this case, and much as the Commonwealth might try, they cannot distance themselves from the stench of him on this case and this investigation. Those secret group chats illustrate the quality and character of his investigation. Remind yourself how, quote, unbiased and an objective investigator, someone who's supposed to be looking for facts. Ask yourself, how did he approach his job late at night, sitting there in his office, deviously looking for naked pictures of Karen Reed and talking about her like she's a piece of meat, talking about her bodily functions, her medical conditions, calling her vile names. I don't even have it in me to repeat what he said about her. He reduced her to an object, and he went further by insulting her. He went further than insulting her, and he dehumanized her. And when he was done betraying that very humanity, he wished for her to commit suicide. That, ladies and gentlemen, is how you frame someone. That's how you dehumanize someone so viciously that you can just pin it on the girl. That's how you rip a person's life apart and sleep like a baby while doing it. And then further that by saying, I hope she kills herself. Ladies and gentlemen, I just began the discussion this afternoon or this morning with a quote about the truth. And I did that because that's what this case is about, top to bottom, tip to tail. It's about the truth, not hiding it or concealing it, but exposing the truth. The truth is immutable. It's not a feeling. It's not a whim. It's unflinching. It's unchanging, and it's everlasting. That's why the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above scrutiny. That's why you stand as the guardian of justice and the protector of justice. The law demands the very integrity that Trooper Proctor and his investigation lacks, and it requires that you cannot convict Karen Reed unless the Commonwealth has met its incredibly high burden to prove every element beyond a reasonable doubt and to a moral certainty. And a moral certainty is defined as the highest degree of certainty possible in matters related to human affairs. It's the highest degree possible in your life. That's the level of certainty. And I'll leave you with this. You have the most powerful tool known to American jurisprudence because you have your vote. No one can take that away from you. Not me, not the Commonwealth, not the court. You may not yourselves. You've agreed to do that, which is the highest calling a citizen can answer in any way. You've agreed to give your community your best. And my question to you is, what will you do with this moment? Ignore the lies, the manipulations, the misogyny, the bias, the lack of evidence? Could you ever do that? Would you ever do that? Or will you say with your verdict, I see the truth and I will not ever look the other way? When you stare the truth down, you'll see that the Commonwealth has not proven its case beyond a reasonable doubt into a moral certainty, not even close. Ladies and gentlemen, Karen Reed is innocent. Do justice and find her not guilty. Thank you.
All right. Good job. Good job, Mr. Jackson. He did a great job. Whatever you think relative to if you believe that she's guilty, if that's your thought process relative to what you reviewed in this trial, Alan Jackson, Yannetti, and what's the other young lady? I want to say Miss Russell, but I don't know if Miss Dr. Russell was the lovely expert, right? So defense counsel did a great job with what they had. They had a lot though. And how many other cases are in this circumstance that do not get this type of counsel, that they don't have the funds to pay for Alan Jackson? Not only are you paying his hourly wage or his trial rate, whatever his rate would be, you're also paying his travel. You're paying for his hotel. You're paying for, if you don't have the funds for that type of attorney, and Yannetti, like I said, is a local attorney, and he is obviously a great attorney because Proctor was mad. The very second he found out that Yannetti was involved, he was upset, wasn't he? Had bad names for Yannetti too. So obviously Yannetti is a great defense attorney in his area, but having the money to have all three of those defense attorneys defend you is not everybody's privilege. They don't have that type of honor to have that kind of funding. So it's really good to see high quality attorneys at work, but sometimes it just makes me wonder, what are the accounts of activity that the Proctor and everyone is involved in that is not able to have the high quality defense that Miss Karen Reed is able to present. So you did a great job. We're on verdict watch. Okay, in case you don't believe me, we're here. We're looking at the one and only fan, and it's deliberation 19 hours, 19 good hours deliberating, and the jurors came in this morning after a couple of hours of deliberation and stated, Your Honor, we have a note for you. So we had a little excitement. We thought we were going to get a verdict. No, they are not unanimously aligned. So whether they are not unanimously not guilty or they're not unanimously manslaughter or lesser offense. They're not unanimous in their vote, and they have to be unanimous. So they're like, we're not unanimous, and we tried, and let us go. And judge said no. And judge was like, nope, I'm gonna let you go to lunch, and then you come back and you do this again. And to be quite fair, I don't think the judge is being rude when she says that. There's a lot of time that went into it, and it's a lot of their time too. It's a lot of the jurors' time. Like Alan puts in the closing, you've been here about 10 weeks. You know, you had your time for selection, you had your time for trial. You've been here relatively 10 weeks, and you've seen 60 some odd prosecuting defendants who didn't really prove a thing, but except for the ones who did prove science, and that didn't go to the prosecution's theory, it was actually against it. But you've been here a long time. So out of respect for all of the work that was done to present the case to you, please take more time and be, you know, be as fair as you can to all parties and try to come to a conclusion collectively. That's the nice thing, the nicest way I can put the way the judge said it. But she was a little like, you're working so hard and we're so thankful. And, you know, just keep working. That was like her presentation right before they got, when they got there, but right before they came out, she's telling them, no, they haven't worked hard enough. This only day 4. So no, they have to continue. So it's like, it's okay. Yeah. She was gaslighting. She's like, yeah, you guys are so great. You're great. You're awesome. You're the best in the West. We love you. Just keep working. Just keep doing it. I can't find the lady's name. And I don't want to be disrespectful to her because she was really good. I don't know. I think she's a partner with Yannetti. And someone had made mention that they were concerned about her delivery. I think she did really good. She worked with experts, and you always need, when you can split the workload, it's always better. It's like, that's trial. Collaborative efforts help. Efforts help a great deal. And I don't care what you ask Google. I said, who is the female defense attorney in Karen Reed trial? And they just want to tell me about Alan. It's not just Alan. He's not the only one. Yannetti's doing a great job. So is the young lady. And I want to know her name so I can say it. Has there been a verdict? No, we know there's no verdict. We're here watching. We're on day 4. And we know there's no verdict yet. Will they set her free? I don't know. So they're more hung up than they are actually in freedom. But it could be 11 to her and 1 to the Commonwealth. It could be. She could have it the other way around, or it could be just one person that's on her side. There's just no telling. At this juncture, they're not telling. But it's a hot topic. This trial is a hot topic. It's taken up so much of my time. So much of my mental capacity has been in this trial. I've tried to keep up with YSL. I can't get my video to load, so hopefully that will load later on today, because YSL will have some new developments next week due to the contempt went up to the Supreme Court. So we're hoping that we'll have, July 1st will be the in-camera review of some evidence. So hopefully we'll have some update shortly after that. And then we're looking for the Supreme Court of Georgia to come up with the conclusion for the motion to recuse, which was based off of the ex parte details that the affidavit that Weinstein filed with his motion to recuse. So we have some potential updates to YSL next week, maybe before 4th of July. You know, trial can be slow in a multitude of ways just because there's many aspects to it. There's the pretrial stuff, the motions that go on pretrial, the discovery that happens before you get to trial or pretrial, and then pretrial, and then after that, then there's the actual trial, and then there's where we are now, the sitting and the waiting and the losing our minds because we want to know what's going on. Just tell us. Just tell us. What do you think? But I do applaud the jury for being resolved enough to say they feel this way, we feel that way, and we're not going to just go one way or another. We've looked at the evidence. This is what we see. We looked at the evidence. This is what we see. That's the great thing about having 12 jurors. You get different perspectives. You get different understanding of the evidence, and it allows you to look objectively at something. If you allow yourself, if you allow yourself to go that far. But it's driving me crazy because I want to know the answer. I want to know. Right now they're deadlocked. Yes, right now. But maybe lunch will make them feel better. Okay, Alan, I hope you sent the lobster and the steak, okay? Medium rare. I hope no, he can't do that. It's totally a joke. He cannot do that at all. Well, anyway. It's funny how you're asking one question of Google and they just want to feed you everything else. And I think it's because because people are like, no, this is really what you want to know. It's not what I want to know. I just want to know the lady's name. There she is. I see her face, but what is her name? Anyway, I apologize. I have forgotten the other attorney's name. I have tried to find it, and hopefully we will find it soon enough so that I can shout her out because she did a great job. Alan just happens to be memorable for me because he's from LA, and you know that's where I'm at. I'm a Cali girl, and then Yannetti is memorable for me as a name because I have to like work really hard to remember it. it's not it's not a common name for me, so it was like Yannetti. So I'm thinking the name. So anyway, I do apologize to the young lady. I don't know that her name was Russell. Gosh, and the judge says her name almost every morning, right? Good morning, so and so. Good morning, so and so, and good morning, so and so. Okay, we don't need that. That's not the one I wanted. This one? No. All right. Let's see what else we can look at because we don't want to look at the fan. The one and only fan. The one and only fan. He is the one and only fan. All righty. Everybody's live. Every news outlet is live. We're live. Everybody's live. Aww. We're on Verdict Watch. What is this? Oh. So the canine expert that supposedly is, or the one that is stated to be a canine expert, I don't know one way or another. His channel is called American Standard Dog Training. So you can go to American Standard Dog Training at your leisure and see what he has to say relative to what the scratches are or could very well have been. I thought I had highlights set aside for us to look at, but I've lost the page. So let me go back. Oh, here it is. Okay. So it's relative. It's thanks to Court TV. We want to thank them up front. Give them a thumbs up. Okay. Alrighty. Let's see. Oh, no, I missed you. Come into focus so you can see me. Here are what they are categorizing as some of the biggest myths within the trial. Court TV.
When a police officer is murdered, it makes
I do not hear. Hold on. One and only fan is still out. The one I'm looking at. I'm trying to find why this is not playing sound. Why aren't you? Okay, well, what's a little technical difficulty? At least it's not the jury verdict that's being muted. I don't know why Court TV is being muted though. Okay, let's unmute the tab. Okay, great. The things that happen live streaming. The real OGs could talk about, really could tell a story about.
His girlfriend is charged with the murder. It makes big news. But when his girlfriend says she was framed by police, what's going on here? Well, and sometimes it's a little more obvious than other times. But the bottom line is things are happening. So let's take a look at what happened today as the jury came in for day 2 of deliberations, and the lawyers and the judge went at it.
I just saw the verdict forms, and as we discussed yesterday, the amendments the court indicated it would make them.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
What you said before you were tired and you needed to think about it was you agreed that there needs to be not guilty options for the subordinate charges under count 2.
I said that it made sense to me, but no, I did not change it upon looking at it because the verdict slip, this verdict slip as submitted to the jury, is exactly how it always is in Massachusetts.
I ask you a question. I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate. It's appropriate.
I make my argument if you don't mind, Judge.
Whoa, okay. Spice. This is not the first, and hopefully it will be the last time, but it's not the first time that Alan gets into it with the judge, and she is making good reference to this is how we do things here, Mr. Out-of-Towner.
Why it's not applicable. For a superior charge, they have to decide that she is not guilty of the superior charge, and that is the starting point of whether or not she is guilty or not guilty of a subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court. How do they decide that she's not guilty of involuntary manslaughter on that verdict?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty, and on the top you're left with not guilty. Okay?
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, and apparently that's how it's going to be because of the court's order. That is not how it should be, and it's our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you. Mr. Yannetti, you've seen verdict slips exactly like this. Okay?
I actually haven't learned.
Have you had no lesser included?
No, we've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option for the lesser included.
Okay. I disagree with you. All right. Excuse me?
How do you disagree with Yanetti's experience? I understand she feels like, listen, this is how we do things here. And Yanetti's like, well, Your Honor, I haven't seen it this way before. And that is his experience. Now, her experience is this is how we do things here. That's fine for her to say, but to bring in Yanetti and be like, you know what I'm doing is right. You've seen this before. And he's like, well, no, Honor, I haven't really seen this particular format before. So he hasn't seen it either. Well, I disagree with you. How do you disagree with someone else's experience? It's like disagreeing with someone's feelings. I feel sad. I disagree with you. Well, how are you going to disagree with how I feel? How do you disagree with what I've been through? Other than, okay, well, it's unfortunate I haven't seen it that way, but I have seen it this way, and this is the way it is for this case. Like, that's a different stance than to just disagree with someone else's experience.
This is funny, Ms. Reed. All right, we're done. There are some minor changes that need to be made to the verdict slip. Does the Commonwealth oppose the suggestion made by Mr. Jackson, which seems like a reasonable one?
No, Your Honor.
All right, so it will be not guilty. So tell me again how you want it.
Sure.
Do you want
not guilty of the offense charged or any lesser included offense?
So big argument today about that. So let me show you the old verdict form so you get an understanding of what we're talking about here. If you take a look at it, you've got count 2, manslaughter while operating a motor vehicle under the influence in the above titled case. And then you've got not guilty as a choice, guilty of the offense as charged. And then there's 2 that are indented. And that was the problem. They felt like that if you found not guilty of the offense as charged, you would check not guilty, and then you go to the lesser included, and there's only a guilty line for those 2, guilty of lesser included offense of involuntary manslaughter. So the form of it was really the problem, the confusion. They end up fixing it by making the top not guilty of the offense as charged or the lesser included. But there's a lot of arguing about this. a lot of arguing about this. So let me bring in
the Patriot Power Generator.
That makes sense to me. And something going on. Wait, we got shush. We have something going on at the courthouse. What's going on in court? What happened? Quebec law and crime. Oh, they're coming in from lunch? Is that what happened? Hold on. What is this? Lana, what are you doing? Okay, so we had the only fan. We did that for hours here. And then law and crime went outside. So we're outside now. I guess they're coming back into the courthouse. What does that mean? 20 hours of deliberation. Okay. Are they just back from lunch? Like, why are we? Did the judge call them in? Like, what are we doing? Law and crime, you're giving us a heart attack.
Alan, how are you feeling this morning?
Great.
How's
So
your
then
day?
you're gonna get a verdict?
Karen, how are you feeling this morning?
Karen, what will you do if you're found guilty?
Mind her business. If she stopped and answered that question, she's going to appeal. What do you mean? What would you do if you're found guilty?
Really, it looks like we're all going to need like 10 for that.
Orders again? Some onlookers? Media? What is this? Is that Larry? Larry walking in by himself? Aww. Aww. That's kind of... I like that. Is this a family? I think we're going back in. Oh, this is footage from outside courthouse earlier. Oh, gosh.
How are you doing today?
Law and crime.
How are we feeling?
They just tricked us. Gosh, dog it. I got tricked. I got tricked. I don't care about it. Okay. That's earlier when they got called into court. I thought they were getting called back into court, but they're just replaying some of their old footage from when they got the note earlier today. I got tricked. I don't like being tricked. Totally. When I saw sound and motion coming from that tab, I was like, oh my gosh, what? We got to find out what's happening. I almost forgot what we were talking about when it came down to what were we talking about? We were in the biggest moments of the trial. Oh, the verdict slips. Okay, so the verdict slips, to me, all that argument, the guy was like, all this argument for the verdict slip, but yet, it was just adding a couple of words. I think every argument that defense can make or any counsel can make is appropriate. You're being a zealous advocate for your client. You want to argue all things possible because it shows that you are trying your ultimate best. You are doing the best job possible to defend or represent the client. And that's your duty. So having the lesser included charge be defined in the not guilty slot, I think it was a great compromise. Being able to say not guilty as charged or not guilty of the lesser included offenses is appropriate. But I do understand the judge's thought too. Not guilty is not guilty. Right? So it was a good little compromise. Let's see what else we can glean from Court TV's video here now that we found out that Law and Crime is just gaslighting us with old footage. As I am just looking at old footage too, but you know, I'm not the one that says I'm at the courthouse, okay? I'm at my house, but not the courthouse. So Law and Crime should not be telling us that they have something new. What's good for the goose is good for the gander. I'm just playing with you, Law and Crime. You just gave me a big heart attack for no reason, but no worries. We'll keep along.
Offense, because if it's not guilty, it's not guilty of everything.
Everything.
So this was kind of much ado about nothing, but you know, it's zealous advocacy. And look, to her credit, after she thought about it, she changed the form.
Yeah. Well, Peter, I'm looking at it, and I try to look at it this way. I mean, we're all lawyers. They're all lawyers. The 12 people in the box are not lawyers. They're ordinary folks. And I think in between the jury instructions and everything else, I think we're a little unfair to the members of the public sometimes, and we presume things. Like in my state of New Jersey, where I practiced, and I don't know what they do in Massachusetts, the jury instructions don't go back with the jury. They just hear them. They hear them once, and then they go decide a murder case. So I think more clarity is always the best choice. Simple and clear.
Yeah, I agree with you 100% that I think Judge Cannoni, and it was nice at least to see that she was flexible. It looked like she was not going to go with it, but she did. And anything we can do to make things more clear and less confusing to the jurors is all to the good. And it was also a smart decision on her part. If ultimately Karen Reed is found guilty of anything or one of these lesser charges, that would have been an appealable issue. Now she killed. There's no chance of appealing on that issue. And I just think, again, anything we can do to make things clear for the average lay person and just concise and easy to read, that's definitely in the plus column.
All right, Rick, unless you want in on this, I think we've dealt with it. The jury also asked for the cert report today, right? They came in, they're looking for that cert report, which is the report relative to the search for these taillight pieces. Can you read that tea leaf for us tonight?
Where's the leaves?
Well, I think, obviously you can go different directions with it. I know that Nick did point out, and I do recall this testimony, that there were, from opening to the actual evidence of the discovery of these taillight pieces, there was a difference in the numbers. Maybe somebody seized upon that. Regardless, I think for both sides, they put this forth, the finding of these as strong evidence for their side. So I think I think the jury could have landed there just because it was something that they started discussing and there was some discord and they said, hey, there's a report. Let's get the report and that'll settle it, because that's what logical people would think. But we're in a court. We're not dealing with logic.
We have about 20 seconds, Joseph. Just 20 seconds. Your thoughts about that request by the jury to get that report, which they're not getting because it's not in evidence.
It's not in evidence. It's hearsay. Typically, they don't get it. What I like about it is they're looking at every aspect of this case, including the technical aspects of the case. There's also information that the CERT team was there while Karen's car was at the Sallyport, the Canton Police Department. So, either side could probably look at it as a positive, but really it's just rank speculation at this point. It's an 8-week trial with 70 witnesses, 200 plus exhibits. No, I didn't expect a verdict today. They're doing their due diligence. They owe both sides a long and thorough deliberative process.
Absolutely. All right, good news, folks. Everyone's staying for the hour. Up next.
A shocking moment in the courtroom as the people accused by the defense of being responsible for.
Okay, so that's an interesting clip right there. I didn't see this, so I'm glad that when I say that it's hard for legal minds to agree, I really do mean it's hard for legal minds to read, because sometimes it's hard for you to come to your own legal conclusion because the evidence pulls in different directions when you're actually looking at it. But wanting the cert report, as I said, is considered hearsay. It was not evidentiary. It's not the evidence itself to the crime. So that's obviously why they don't get it. Just like when it came down to the opening and closing statements, the closing statement specifically, the judge was like, "No, you don't get your notebook and pen," even though Alan Jackson gave them timestamps and videos and evidence to go look at to point to his point. They didn't get to write those numbers down. So hopefully they have, the greatest memory ever. Oh, the judge's name is Beverly Cannon or Cannon. I didn't, or something close to that. Sorry, Judge, didn't know your name for a very long time. So the Honorable Judge Beverly. And I'm getting a phone call. Why? All right, I got to take this call, guys. I'm going to let you guys have this one. Hold on 1 second.
For the killing of Officer John O'Keefe, take a seat in the courtroom with the loved ones and family of John O'Keefe.
Sorry, guys. I was getting a call from a client. I had to take that real quick and get them situated. And so don't worry about burgers. You make the best burgers. You don't have to buy anybody else's burger. We don't sell burgers on this channel, okay? We offer things that are free. And I want to go back. I hope you're not mad at me. But we're here. We're just sitting around waiting for the jury, right? So you can't get too mad. I just want to see this.
Loved ones.
I don't need to hear. And I feel so bad for the loved ones of Officer O'Keefe. They deserve so much more than what they're getting. And it is unfortunate that more was not done just to prove the case, to be good stewards of the evidence, to actually investigate completely and wholly. That was not to their benefit. I am very saddened for them. I wish this thing would get out of my way. Get out of my way. I just want to see the people. I just want to see the witnesses that are being alluded to as being conspirators. There you go. There they go. There. Can we get to the page? Okay, but not the loved ones. I don't want to there they are. I don't want to exploit the loved ones. Okay, so here we are. I hope you guys can see where we are on this. Yeah, looks like you're there. So Brian Albert is the owner of the house. The suspicion that arises with Mr. Albert and his wife, which I thought was, well, she's not a witness. Or Nicole, there she is. Okay, so Brian Nicole Albert is because that is the home that his father built. They've had that home for many generations, and they have since sold the home. Now, just to play devil's advocate, Jennifer McCabe gives some kind of allusion to the fact that they are harassed as a family because there are people that believe all of these people have something nefarious to do with what happened that night. And so they're covering it up, and consequently, they're being harassed. Maybe that's the reason why they sold that home, but that's not what they say on the stand. On the stand, Cole Alberts talks about they sold the home because they wanted to downsize because the kids were older and they were moving out of the house, when in fact the only child that does not live in the house is Caitlin, but Brian Albert lives in the house, I believe. Brian Albert lives there, and I think one other sibling or whatever have you. So it's like one of the children moved out, and so now all of a sudden we're gonna downsize, and the house is too much for upkeep. So maybe it is a coinky dink that they all of a sudden sold the house in November, but I will say, as an agent, as a real estate broker, I'm telling you, we don't sell houses in the winter. I mean, we do, but ideally, the peak of the marketplace is in the spring and summertime. And no one ever asks them that. The peak is summertime. That's when the highest street traffic, foot traffic, the highest amount of people are going to really come out and look at the houses for the open house. So a lot of times agents will say, well, let's prep the house, let's prep the property. We'll do some advertisements in the spring, and we'll do our open house late spring, early summer, because it's sunny, it's beautiful, the weather is good, the house sparkles a different kind of way under the sun, and it's really the cream time. Like, that is the peak time that we have ourselves. So to be selling in November, to me, is suspicious in and of. I'm like, and you're telling me it's snowy in January, and it's so much snow. People are falling and hitting their heads on ice and dying. Okay. I don't know. The real estate agent in me is like, yeah, no, my team, nah. We're not selling in November if we don't have to. Okay, it's a lot of, okay. So just going back to the law and crime feed, they're still just reviewing footage from earlier, which is now individuals that want free Karen Reed, and okay. So we'll let them have that moment. We'll stick with where we are. I don't want to get into the hyperbole and all of the mayhem that's going on around court. I'd rather hear about what's inside the court, the trial itself, and now the jury. Okay, so Brian Albert Jr., God bless his little heart. He was just trying to have a birthday party. And he's the chillest. Out of all these people, I don't think he's trying to cover a thing up. I don't get that from him at all. The way I saw him was, me and my friends were doing our thing. When my parents came home, my friends kind of left. Like, they kind of like changed the swing of it. So someone said that because it was his birthday, Nicole Albert is like, let's go home and celebrate with Brian on his birthday. Everybody bring the party back to the house at Fairview. Because the waterfall is like, got to go, boo. Don't care where you go, but you got to go. It's time to close up. There's a blizzard. We need to go home. So instead of going home, they're like, come to the house, let's do the after party. Okay. The after party. Okay. Some people agree. Well, Keith's is like, no, don't you even think it. All right, got you, doctor. She's a pharmacist. She's like, I've been working all day. I'm going home where I was before I got here in the first place. No problem. Brian Albert Jr., bless his heart, he says, I don't know if he says introverted specifically. He says, I'm to myself, I'm conservative. I have a small number of friends. We kind of hang out a little bit together. I have a small circle. They came over. We're doing adulthood things because he's like turning 21, 22, something like that, 23. He's like in his young 20s. And we're being adults. And they're being so responsible. Like people have rides home. Like I don't know, but Kaylin, she was being a little high maintenance according to her man because he had to drive back to go get her after just leaving her just moments before. And it's a 30-minute drive, and he's supposed to get up early to work and plow and be on call from 3 a.m. to God knows when. Hey, he must love it enough, right? He's like, she's high maintenance. I just did it because I didn't want to argue. So real. That's a real one. But Brian Jr. is like, I was just having fun on my birthday. And his birthday now has this cloud, not necessarily to him specifically, but there's this element of reminder every time around his birthday that someone important enough to be close enough to his family has died, and his family is being blamed for it. So to Brian Jr., for that, I shut you out and say, I'm so sorry for anything that the internet is doing that's inappropriate, anything that the community is doing that's inappropriate. And hopefully you are taking care of yourself and you're taking care of your mental health, your spiritual health, and your physical health. And happy birthday. Many, many birthdays. Keep them happy. Remind yourself that the birthday, there's lots of things that happen around your birthday. What you are celebrating is yourself and your life and your experience. You do not have to have negative birthdays. So hopefully your birthdays are jolly and of good cheer from January, whatever, I think 28th or 29th, every year into many futures. Okay. Now, Kaylin Albert, I don't think she really has a dog fight in this that people may think of. I think she's just a little snobbish. Like she's just high maintenance. She's got her thing going and she's young. So she's like, look, leave me alone. Leave us alone. And she's defensive. But I don't think her defense is, we did this, so I'm covering it up. I think her defense is, leave my family alone. Leave my brother alone. Leave my family alone. And stop making much happen. I think that's what she really believes. I don't think she understands or believes or has the ability to look at this on an eagle's eye perspective, or come outside of being in the middle of it and look at it objectively. I think she just really believes that they are being victimized, and she believes her mom, she believes her dad, she knows her brother didn't do it, and she knows she didn't do it. So leave them alone. That's the way she feels. That's my impression. Now, Colin, yeah, Colin is a different one. I think I can't be definitive in my thought with it. I don't have yeah, he did it, but I think it's not far-fetched that he had involvement, and it would not, and to the degree that everybody else, like Brian, Nicole, and even maybe Matt, Jennifer, would be like, we're gonna help Colin out because he is just a kid. But I really don't necessarily have I don't have a complete way that he did it. I just feel his involvement would not be shocking. I don't necessarily know that he was involved. I just feel it would not be shocking. But anyway, of all accounts, most witnesses say he had left, and they believe he had left before John got there. Their timelines are so screwed up. relative to 12:15. They were like what 12 o'clock at first, and then they were like 12:30, and they didn't leave the spot until 12:17 and 12:15 and whatever out. So the timing was off. Everyone was drinking, so it's normal to not have good timing. And some don't drink and still don't have a concept of what time of day it is without looking at their clock. That's not unheard of. But based upon, I think Jennifer came in or someone came in, Colin was leaving, and I think Caitlin expressed the same, that Colin left. And so it's not far-fetched that he left, and he may have very well gotten home prior to John's arrival. But if it is found somewhere down the line that he had involvement, I wouldn't be shocked. I just don't know definitively if he did or not. Brian Higgins, I believe, was involved. I think Brian was involved just because he was there with, I think, gosh, there's so many Brians. I think Higgins was involved because Albert Sr. was involved. And I don't necessarily think it was intentional. Like I said before, I think for them, their involvement may have been to protect Colin, or their involvement could have very well have been, we're having fun with this dude. We had a fight with him. Very simple, punch here, hit there, but now he's dead, and that's not the outcome that they were expecting. And the dog, now that he's on the ground and they're attacking him, the dog gets down and bites him, and they get the dog away from him and cover it up, and Chloe has to go. That's how I feel it went down. That's my opinion. Jennifer McCabe, I don't know if she knows nefarious activity happened, but I know that she is like protecting her family. And in that protection, she will go as far as she needs to go, if not further. I don't think she has a line. I don't think she has a stop. Whatever it takes to protect her loved ones, she's willing to do. And I think her involvement is like, okay, we're all gonna be on one accord. We're all gonna have this straight. And I think the guys are kind of like, yeah, let Jen take care of keeping everybody straight and in order while they rehome the dog. Matt, he probably had some type of involvement. His testimony, his demeanor on the stand was so rude, so disrespectful, and absolutely deplorable, in my opinion. And I am the outsider of outsiders. I'm outside of the state. I have nothing to do with any one person on this case, including Alan Jack, nothing to do with him. And I am completely outside of most aspects relative to this case. However, what I saw of him on the stand in real time, not someone's recount, but in real time, was very disturbing to me. And I believe Jennifer and Matt McCabe were sitting next to the family towards the closing arguments, during the closing arguments. I don't know if the family has the ability to see what someone on the outside can see. I understand there's more to it than what we know, because obviously testimony is going to be curtailed to what the evidence is. It's not going to allow you to pontificate and go into your daily journals and talk about all the particulars and details. So they probably have a united experience that makes the family feel comfortable around them. And it's unfortunate because I don't think Karen did. I really don't. I don't think she had anything to do with it. And I think these certain individuals in this sector here had something to do with the direct effect of him dying in the cold, because knocking him unconscious and knocking him to the ground, and him dying because no one gave him aid. But I don't think it was intent. I don't think anybody intended it. I just think it happened that way. And the others who are involved, most of the others who are involved, are like the cleanup crew or the, you know, the framing of the evidence. All right, let's see. Verdict watch. Yep, they're back to the fan. So they were 20 hours of deliberation. Law and Crime went back to old footage. They're trying to keep their audience entertained, much like I'm trying to keep you entertained. And that wasn't necessary for me. So if you cared about what's going on outside the courthouse, I say law and order all the time, but it's Law and Crime. You can go and check their channel. You can play some of what happened outside of the courthouse this morning.
Accused by the defense of being responsible for the killing of all.
Julie and Sarah just were there. Okay. I don't think that's why I said I wanted to see who they were accounting for was actually the nefarious actors. Julie and Sarah were just there and they didn't see anything. Julie says she thought she saw something, but she was drunk and she laughed it off and nobody heard her say what she said. All right, Miss Julie. Maybe. But you know, there's this impression that happens that once you have been told something happened, that their body been found after something, you kind of might have the impression like, maybe I did see that. And then it doesn't necessarily mean that you did, you just feel like you did. I don't know, maybe she saw something, maybe she didn't, but whatever she saw was not addressed at that time.
Officer John O'Keefe take a seat in the courtroom with the loved ones and family of John O'Keefe. What impact will this have?
On the next episode of Accomplice to Murder.
It looked like
She couldn't find TV.
Oh, that's a commercial. Okay, well, thank you for TV.
I think it's great. It's more intimate. It's more in keeping with what you would expect a traditional courtroom to look like, and I'm very happy with it. Very happy with it.
So before it was a switch of the courtrooms inside the courthouse for this major trial, right? Major trial, major interest. The original courtroom where all the pretrial hearings were, that was the big, beautiful, historic courtroom. Lots of room for everyone. All the big trials in Dedham. This is where you have them, including like Sacco and Vanzetti was in this courtroom, for goodness sake. But Alan Jackson didn't like where the witness stand was in relation to the jury box, so they ended up with courtroom number 25. Let's take a look at courtroom 25. Let me take you inside there. And this, ladies and gentlemen, is a much smaller courtroom. It's tiny. Look how on top of everyone, each other everyone is. As you top of everyone.
Okay. So, okay, what do you think? For me, the other courtroom that Alan Jackson took issue with had a lot of general space. Okay, general space is over to our right back corner here. That's where the defendant's family sat, at least in the front row. And then the other general space was over to the left front row, which was the victim's family. And behind them was the media. So those benches, you know, pews that feel like church pews, look very painful to sit in, because I do. That's like one of the things is like every church who has this type of pew, put down a cushion, because no derriere is comfortable in that type of seating. Okay, so anyway, sorry for my epithet now that I've gone off topic. Anyhow, what Mr. Jackson took issue with was before that the witness box was, I think, on the other side, and it kind of was hindered a little bit relative to where the jurors sit. So the jury sits in those black seats that are off to the right up along the wall, and then the witness box for this room is right next to the jurors. The importance of seeing the witness cannot be defined enough. because being able to see the witness in the witness box is extremely important, especially with witnesses that roll their eyes, snark, make weird smile, much like Matt McCabe was doing. Witnesses who slouch and look defeated and guilty, or they've done something wrong, a lot like Proctor on cross examination. That type of expression does not get captured in the record, and the witnesses don't get to view the court reporter's record. They only get to view the testimony as presented in the trial, and they have to take the notes, to obtain it. And that's why the closing statements are so important, because they help to summarize what you just saw for 9 months, for 9 weeks, right? Okay, that's the box. So that's the reason.
Of each other, everyone.
And the other big thing about it is, and I don't know that they've ever talked about it, I think also it limits the trial being a spectacle to the jury. If you are a juror, and the courtroom is packed, and you have, you have 20 pews, and they're all packed, you have reason to go, oh, this is a frenzy. And then if you find unfamiliarity with who's in the seats, you're like, oh, this is a lot of media attention. There's a lot of outsiders that are here. You can take wind of that. That is common sense. You can take note of that, and that may skew the jury's perception of the trial. So another factor that I think Jackson took into play, that I don't know if he ever argued it, is we don't want so much room because we don't want so much public. We want it to be true local individuals, the media, the professionals, the families, representation of what a more unsalacious. Wait, something moved. Oh no, the fan is still going around. Never mind. Never mind. You want to go to something that's unsalacious in terms of the viewing of the courtroom. So the smaller courtroom was cramped. It was hot. It had its issues, but I think it was a good play for the
One is, as you walk into courtroom 25, it's a smaller courtroom. So let's take a look at it from the perspective of the witness box, right? And we could drop those little letters there. So when you look from here, responsible for the death of John O'Keefe and the cover-up of all of this.
Right.
We're talking about Jennifer McCabe, Brian Albert, Colin Albert, all
else. Of course, on the other side of the coin, somebody's going to be looking and saying, well, who isn't there? Oh, Higgins isn't there. I guess Higgins did it by himself.
Joseph, what are your thoughts? And again, at one point you did represent Colin Albert.
That's a point. Oh.
So I think that this is really a message being sent by the O'Keefe family where they stand.
Right.
The O'Keefe family, I think, is telegraphing to the jury that they don't buy into the cover-up, that they support the Alberts and the McCabe's. Really, as it relates to the courtroom, this is a case of huge public interest. I hate the decision to hold it in courtroom 25. I think it violates the right to an open and public trial. The way this process has been working out, Karen Reed has her section. It seems like she can invite people to her section. The O'Keefes have their section. They can invite people to their section. It has nothing to do with Karen Reed and the O'Keefes. The public has a right to be there. We shouldn't have just 10 people from the press. Poor Matt camping out in a chair 12 hours through the middle of the night, not getting good sleep. It should have been in the bigger courtroom. But I think this is a message from the O'Keefes that they don't buy the cover-up. And it's a message to the people that were the target of the third-party culprit defense saying, we've got our head held high. We have nothing to hide. We didn't do anything, and we're here. We're not hiding. We're here front and center for all to see.
Wow. Thank you. Oh, as I said, and I stand by it wholeheartedly, when you get more than, a handful of attorneys, legal-minded folks to agree, you've created a miracle. Because I wholeheartedly disagree. But I think it was a good play by Jackson, and I think that's the reason why he did it. I don't think it had anything. Well, okay, it does have something to do with the witness box. I think that was a great call out, but I think he also much more appreciated the smaller space because it was more controlled. And to the effect that of it being public, we are publicly viewing the trial online. So that was probably the major compromise, is that you have the court TV, the long crime, the major streaming. So yeah, we can see it as a public. It doesn't violate our right to the public trial, but it does control the mayhem, and I think that is to the benefit, truthfully, Commonwealth, family O'Keefe, and to Karen Reed collectively. That the mayhem of any extraterrestrial individual, the complete outsiders, the me's, I wouldn't go down there, but the me's who don't even live in the area, being outside at the courthouse steps with the signs, with the t-shirts, with the extra, being inside the courtroom would be distracting to the jurors, would be to the detriment of justice. So yeah, we don't agree on that one, but it was cool to see. He's defended Colin in the past. That has nothing. That does not. I don't think that makes him. It might affect his opinion, but I don't believe that it affects it to a point where he cannot be impartial. He gave great commentary to the fact that it does show having the O'Keefe family, having the Alberts and McCabe's there, does give a good united front to, we don't buy it. But we don't need them to buy it. The jury does not need the O'Keefes to buy it. They have an inherent bias already, right? They have an inherent bias already because they are affected directly with the outcome. And so when you want someone to investigate a crime that has happened to you or to your family, you are in belief of their investigation. So it's hard to hear anyone criticize their investigation. We don't need to know if they buy it or not. The jury doesn't need to know that. They just need to know what the evidence is and what the evidence says. And so consequently, it gave a united front. It gave a presentation. It was united. It was definitely across from the jurors. They could see it up front and center, but their focus was this way. So the times that they were focused over to the left would be at the attorneys that were making the questions, And then they would, do the tennis look. Remember, you're looking at the attorney, ask the question. You're looking at the witness, respond to the question. You're looking at the attorney, ask the next question. You're looking at the witness, respond to the next question. So there's very little of like, who's over in the box with the O'Keefes? Like, you're not looking at the O'Keefes too much, right? It's more about the witness. It's more about the judge. What is the attorney saying? Do they take notice of that? Yes, they saw that they were there. They also saw that Karen Reed's family was there. It's good to be there. It shows unity. It is good to be there to show interest, but it does not give definition to the evidence. All right. So jury watch has been what it's been. I've enjoyed my time with you. We've been here for a few hours now. And the very second I go do real business, that's when they'll come back and have a whole decision, right? The verdict will be in. But anyway, just to sum up what we did today, thank you for hanging out with me. I hope you enjoyed yourself. Like, share, and subscribe. Look forward to hanging out with you more often. Today, we were able to take a peek, see what's going on with the jury. We're on verdict watch. We are chomping at the bits. We're tapping. We're losing our minds. We're going like this. We're like, are you serious? Like, obviously. We have our opinions. We believe what we believe. We know what we saw. And the jury said, guess what? We're not of the same mind, right? They are feeling like they're deadlocked. They feel like they don't necessarily agree, and they don't have a unanimous decision to render. They wanted to stop. That was a couple hours into today's deliberations. And judge was like, yeah, let's talk about it. Commonwealth said, no, it's only day 4. We're only the first week. This is really not enough time to, we're doing a murder trial here. There's complications. And hey, guys, put it in the chat. Do you think this is why the Commonwealth called like 67 witnesses? Because I don't think Lawley is dumb. I think Lawley is smart. I think he's intelligent. And I just wonder, did he think this case sucks so bad, I'm going to just put everything, so that at the end of the day, I could say, look at all the witnesses I had. I had 67 witnesses that proves she did it, when in fact, you really couldn't prove that. I don't think he proved his case. But was that the theater? Because there is theater when it comes to presentation of trial. Alan Jackson's presentation of theater was his candor. It was his inflection. It had to do a lot of his verbal cues, his snark, right? That was his theater. Was Lawley's theater presentation, I'm going to put a million things on a million and one things on the jury's list of evidence, and all these witnesses up and confuse and shuffle the deck to where they just have to take my word for it. I wonder if that's his strategy, his theatrical strategy. But whatever the case, he said it hasn't been long enough. It's lots of evidence, Your Honor. So clearly they don't have enough time. They need to take more time. And Yannetti argued, gave a salient argument. They said they have exhausted their ability, and they've looked through all of the evidence at this point, 200 some odd pieces of it. They've looked at it, and they don't have a conclusive, collective conclusive result. They, are not in agreement. They are deadlocked. That would be mistrial. Judge says, oh, that was great. Thank you, guys. No. No. Have some lunch. Go think about it, and woo 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 and woo woo woo, and then do some more work. She sent them back. She did not agree that they were able to truly exhaust themselves of all potential review due to the voluminous evidence that was presented, and consequently she's making them go back. Well, I'm gonna look one more time because I have to do real business. Oh, that fan, the one and only fan, the one and only fan of this room. I'm the second fan because I think, or the third one, because I think Jackson did a great job at keeping, or the defense as a whole did a great job at keeping the mayhem out of the courtroom by choosing the smaller room. And that may not go well with the other commentator who said he hated that. He wanted it to be more public, but I think that was a great strategy. All right, so the one and only fan is flickering around at Law and Crime. We have watched this morning. If the verdict comes, then, we'll talk about it. But right now, we're still waiting. Day 4, 20th hour of deliberation. Had a great time with you. Lyric Armstrong, your real estate agent and advocate. Look forward to seeing you at the next video.